Thank you for coming to this great committee meeting. And you're going to hear some wonderful witnesses on these various bills listed this afternoon. I want you to know that we're about to get started. The Select Committee on Youth Health and Safety will now come to order, and the clerk, please call the roll.
Thompson.
Present.
Hull. Present. Allison.
Here.
Capriglione.
Here.
Dutton.
Here.
Ann Johnson. Tracy King. Landgraf. Lozano.
Here.
A quorum is present. Anyone wishing to testify before the committee, please register at the kiosk located in the hallway behind the hearing room. If you require assistance in registering, please contact the committee clerk, staff. Before I begin the first bill, I want to remind those witnesses who have registered that by filling out and submitting your witness affirmation form, you have agreed to give your testimony under oath. Members, we have several witnesses for our bills this afternoon who are registered, and the testimony will be limited to 3 minutes as noted on our posting. I respectfully ask our witnesses to adhere to our time limits. We value your time, each of you. We appreciate you coming to testify. We're glad you're here. But we want you to give your testimony so that we would understand what your position is. And it's really not necessary to be repetitive. I know some of you have written your testimony down. You love to read it, and you're all excellent readers. And we are too. And members, does anyone have any comments or questions before we begin? Okay. The chair lays out House Bill 772 and recognizes author Representative Allen to explain her bill.
Thank you, Madam Chair. House Bill 772 relating to corporal punishment in public schools. Currently, corporal punishment is legal in schools in Texas. State law does not prohibit the use of corporal punishment in public schools, and the decision is therefore left to each individual school district. Corporal punishment is defined as deliberate infliction of physical pain by hitting, paddling, spanking, slapping, or other physical forces used to means for discipline. Corporal punishment has been banned in several Texas independent school districts, but not all. So HB 772 prohibits the use of corporal punishment as a form of discipline in Texas public education system. Madam Chair, I think we have persons who want to testify, and I reserve the right to close.
Members, are there any questions of Representative Allen? The chair calls up Morgan Craven, Amanda Afifi, and Cindy Decker. Somebody's missing? Okay, you are?
I'm Cindy Decker.
And you are?
Morgan Craven.
And Amanda's missing. We have another witness. Okay. All right. Cindy, you want to start off? I think we have you registered as Cindy Decker. You're representing yourself. Is that correct?
That is correct.
Okay, then, and you are for the bill?
I am for the bill.
You have 3 minutes to tell us your position.
Okay, thank you very much. Thank you for taking your time to listen to me. My name is Cindy Decker. I am for Bill 772. I am a mother of 3 children, 2 of which have graduated out of the Texas public school system, thankfully, are now in college. And I have an 11-year-old son who's a 5th grader in the Texas education system with autism spectrum disorder. You can imagine my surprise when I had 2 children that had now been in school long before my 11-year-old started school, and I had no idea that there was still corporal punishment within the Texas school system. My 11-year-old son, as an autism spectrum disorder special needs child, had a situation where, in being dysregulated in school one day, was retained and restrained onto a chair. Weeks later, as I was giving him a bath, I realized that my son had bruising on his arms, and I was never notified of what happened to him and why he had bruises on his arms. These are the youngest of our children. They're the most vulnerable of our children. And I will tell you that in 2020, I know there's a bit of a whistle, sorry. In 2020, Disability Rights Texas examined statewide data and found that students with disabilities experienced 91% of all restraints done in our Texas public school system, and they make up only 10% of our student population. So once again, I ask you to please go for Bill 772 in order to protect our most vulnerable children.
Members, are there any questions of Cindy Decker? We thank you for your testimony. Morgan Craven, we show you as representing IDRA, Intercultural Development Research Association, and yourself, and you are for the bill. Is that correct?
Yes.
You may proceed.
Thank you. My name is Morgan Craven. I'm the National Director of Policy, Advocacy, and Community Engagement at IDRA, and I'm testifying in support of House Bill 772, a very important bill that would ban corporal punishment in Texas public schools. And a huge thank you to this committee for hearing this bill and to Dr. Allen for making this important issue part of your life's work. When Texas public school districts adopt corporal punishment policies, adults are able to spank, paddle, slap, or hit children to discipline them. And in 2017-18, that meant 468 Texas public school districts had corporal punishment policies. Over 13,000 Texas kids were hit in their schools more than 21,000 times, and that should be alarming to everyone. Not only has corporal punishment been shown to be ineffective and even counterproductive as a discipline tool, but it causes harm to children and makes school environments less safe in nearly every way you could imagine. Corporal punishment can lead to serious physical injuries, long-lasting negative effects on children's mental health, and is associated with lower academic achievement and higher rates of school dropout. It is disproportionately used against Black students and children with disabilities. It can undermine the authority of adults and make it more difficult for them to establish positive relationships with students, which we know is a critical component of school safety. And corporal punishment models violence as a system of conflict resolution and can prevent schools from investing in the evidence-based strategies that we know work to support kids and build up safe school climates. The list of negative consequences is long and far-reaching. And I know that you weigh many considerations in policymaking, including who should have the authority to make certain decisions, the cultural or community practices that influence what happens to children in schools, and even your own experiences. But we cannot leave the decision to end corporal punishment in schools to anyone else anymore, and we cannot allow a legacy of harm to persist in our schools, even if some of us experienced it. The most critical consideration, and the one that outweighs all others, is the health and safety of children in their schools. There is no argument strong enough and no policy concern important enough that we should place it above the well-being of kids and above the very clear evidence that corporal punishment in schools is thoroughly and completely harmful to children and school climates. We have a Texas law that promotes and models violence in schools, making them less safe. A law that allows adults to hit kids in schools, some who are as young as 3 and 4 years old, some who are teenage girls, many who have disabilities, a disproportionate number of whom are Black. And we can have all sorts of debates about what's appropriate for children to learn in schools, but we cannot disagree about learning violence. And one clear, easy way to reduce violence in schools, to accomplish the mission of this select committee, is to pass House Bill 772 and finally eliminate corporal punishment in Texas public schools. You have an issue brief as my written testimony. I'm happy to answer any questions that you might have about that.
Chairman Dutton.
Thank you, Madam Chair. Should a parent be allowed to use corporal punishment at home?
So I can't comment on what parents do in homes, and one critical part of this bill is that it explicitly excludes what happens in homes. It is clearly focused on what happens in schools. So I'm really focused, and our expertise is in what happens in schools and how we best support children in schools and encourage safe and welcoming school environments. And what the evidence shows is that corporal punishment in schools is not consistent with that goal. And so the bill is very clear that there are differences in what it is focused on and what it would mandate.
So could a parent use corporal punishment under this bill at school?
The bill does not speak to whether a parent could come to the school and use corporal punishment. It speaks to corporal punishment as a policy within the school district, and it prohibits schools and school employees, volunteers, or independent contractors from using corporal punishment in schools.
Well, the way I read line 15, lines 15 and 16, it says, this subsection does not apply for corporal punishment administered off campus by a parent to, so that means on campus it would apply, right?
I think it could, but that to me is not as clear. I think what's clear about the bill is that there are no corporal punishment policies that are allowed by the school, and that applies to school employees, volunteers, and independent
I got that. I was just.
And I do understand what you're pointing out.
My question was whether or not a parent could actually do that at school. And it seems like that this prohibits that. If a parent wanted to use corporal punishment at a school against their own child. Anyway, thank you. Kim?
Members, are there any further questions? Thank you both for your testimony.
Thank you.
Okay?
Show Amanda Fifi for the bill, but did not testify.
We show that Amanda Afifi was for the bill and she did not testify. Is there anyone else here wishing to testify on, for, or against House Bill 772? If not, the testimony on House Bill 772 is closed, and the chair recognizes Representative Allen to close on her bill.
Thank you, Chairwoman Thompson. I want to thank the witnesses who came today to testify. They are certainly clear on minority children are most likely to be, you have corporal punishment used against them, special education kids or those kids with special needs. Corporal punishment has a negative effect on children. It causes dropouts, it causes mental health issues, and it teaches violence. And sometimes that violence comes back to school in the form of shootings, etc., as a form of vengeance. And so this is my 18th year here and my 9th session, and I have filed this bill every time. And one of these days, I'm going to get it passed. People will realize we can no longer abuse children. Too many kids are being killed these days. They're being shot. The number one cause of children's death, I heard this morning on the television, is shooting. We're going to beat them and shoot them and do other things to kids. It's unreal. It's just time that we stop this kind of abuse. I close.
Members, are there any questions of Dr. Allen? Thank you, Dr. Allen. Members, the chair moves to leave House Bill 772 pending. Are there any objections? The chair hears none. The bill will be left pending. The chair now lays out House Bill 773 and recognizes its author, Representative Allen, to explain the bill.
Thank you, Ms. Chair. The bill would be, 773 would prohibit the use of schools initiating early pickups if being used as discipline management techniques. That means if a kid gets in trouble and in the middle of the day, we call a parent to come pick him up. That is an inconvenience for parents in the middle of the day.
Representative Allen, let me lay out your substitute. Okay. Representative Dutton, Officer Committee Substitute. Okay. The chair is laying this out, and would you tell us explain the substitute?
Yes, I
will.
To
House Bill 773.
House Bill 773, the original bill on line 16 wants state a disciplinary management technique and the substitute removes disciplinary management technique and adds line 16 to read discipline management technique. Change one word. 773, the original bill reads, requires disciplinary action. The substitute reads, requires disciplinary action and adds the teachers to remove the students, teacher to remove the disciplinary action and adds requires the teacher to remove the students under section 37002. The amendment to the substitute removes page 1, line 12, may not release a student to the student's parents, and add, may not require students to go home before the end of the instructional day and after the parent receives the school-initiated communication if the release of the student is required.
Members, are there any questions of Representative Allen? Okay. Oh, Representative Allison?
Thank you, Madam Chair. Dr. Allen, just so I'm clear, are you saying that the school is prevented from requesting that the parents come and pick up their child at any time?
Yes, in the middle of the day. You know, like some teachers will call the parent and say, you need to come and get your kid in the middle of the day, or release the kid to go home by himself in the middle of the day, which is really an inconvenience for parents. And many parents have, who brought me this bill have lost their job because they have to go home in the middle of the day. And some teachers call 2 or 3 times a week. And so this just prohibits that. Wait until the day is over and confront the parent.
Regardless of the circumstances? Regardless of the discipline issue with the student?
I don't know what, I cannot think of an issue that would be so severe unless kid has a gun or something. Then, well, that's no, today, that's not unthinkable.
Okay.
But if it's that profound, of course not.
Okay, just wanted to clarify.
We're going to use our intelligence here.
Thank you. Thank you.
Are there any further questions, members?
May I finish laying it out?
Please.
Thank you. The bill would prohibit the use of school-initiated early pickups if being used as a discipline management technique or as a reason to the student's behavior when the behavior does not violate the student code of conduct and requires disciplinary action. This will reduce negative family impact and lead schools to look at an underlying need for students to provide more effective services or support that keeps kids in school and learning, and that's important. There is a committee substitute, and I read that committee substitute into language, and basically that's what the bill does. Madam Chair, I think there are witnesses, and I reserve the right to close.
Members, are there any further questions of Dr. Allen? Jolene Sanders, Anita Scott, Jacqueline Benastanti. All right, who wants to go first?
I'll gladly go after.
And your name is?
My name is Jolene Sanders. I represent the Coalition of Texans.
Jolene Sanders, we have you registered as representing the Coalition of Texans with Disability and yourself, and you are for the bill.
Yes, ma'am.
You may proceed. You have 3 minutes.
Thank you. I appreciate the opportunity to be here. I appreciate Dr. Allen filing this bill again. Just to kind of, for those of you who are not familiar with this practice, to give you just a brief overview. As Dr. Allen mentioned, this typically happens with students with disabilities or students of color. And Representative Allison, I'd like to just kind of address the question that you had is we're talking about instances that are not, they're actions that are not a violation of the code of conduct. So for things like that might warrant in-school or out-of-school suspension or even expulsion or referral to, to another placement, These could be things as, as simple as, I can't get Sarah to participate in the group. Sarah has autism and she prefers to be alone. We've also heard families who have come to us and said, I get called in the middle of the day saying, hey, Sarah's having a good day and we want her to end on a good note, and they're called to pick up. This is problematic for a number of reasons. Not only are these kids not in class and learning, and they're not having important interactions with their teachers and their peers, but as mentioned, for parents and who are constantly being called, and I'm talking about almost daily, to come pick up their kids. Obviously, there are implications for employment, financial stability for the family, stress for the entire family unit. And for students with disabilities, what this does is it allows schools to circumvent requirements under federal law after a student has been removed 10 times to conduct a manifestation determination review to determine if the behavior is a manifestation of a disability. And so because that's not being done, these kids are being funneled into even more restrictive placements and are experiencing higher disciplinary action. It is also reinforcing for some students if they know that they're going to get to go home early. It's a pattern of behavior that's learned. And since you all remember pre-K through second suspensions being eliminated several sessions ago, we're seeing this used as a replacement. They know that, hey, we can't have these discretionary out-of-school suspensions for these students, but this is not documented. And I'll finish with this. Because it's not documented, these parents are getting truancy notices, and they are unable to defend themselves because they were not the ones who initiated keeping their kid out of school. So CTD is very supportive, and we hope that you will vote for this bill.
Members, are there any questions? Members, are there any questions? Ms. Sanders. Thank you. All right, Anita Scott. Good to see you again.
Thank you.
Anita, we have you registered as representing the, Texas Home School Coalition, and you are neutral on the bill. Is that correct?
Yes, ma'am.
You may proceed.
Is her mic on?
Is it on?
Is your mic on?
I think it's off.
Do you want to press the button right down the bottom?
Is that it?
Do you want me to try this? Okay. Okay. This one is on.
Yes.
Good afternoon, Chairwoman Thompson and committee members. Thank you for the opportunity to speak today. My name is Anita Scott. I am representing the Texas Homeschool Coalition, and I'm testifying on House Bill 773. THSC is the largest statewide advocacy organization for homeschooling and family rights in Texas. We advocate for the interests of up to 700,000 homeschool students in Texas. I want to thank Representative Allen and her incredible staff for accepting alternative language that improves the efficacy of the bill. We were able to work with the office to clarify the intent of the legislation, which ensures that schools are not overreacting and unduly penalizing a student by sending the student home for reasons that do not reach a level of behavior that would necessitate such discipline measures while also protecting parental rights. We appreciate Representative Allen's intent behind this bill, and we look forward to continuing to work with her and her staff on this and future legislation. Thank you again, Representative Allen, and thank you, committee members, for your time and consideration. I welcome any questions.
Members, are there any questions? Thank you so much.
Thank you.
All right, we have Jackie.
Jackie Benestante.
Pronounce your last name again.
Benestante.
Benestante. We have you, we show you are representing the Autism Society of Texas, and you are for the bill.
Yes.
Okay.
Okay. All right, thank you. Yes, I'm Jackie Benestante, and I'm the Executive Director at the Autism Society of Texas. I'm also the parent of a student with autism. I've worked there 7 years, and we provide free information and referrals to parents as well as autistic adults statewide. We served 105 counties last year through our free Navigating Autism program. One call really stood out. We had a single mom call us for help. And she had a young kiddo with autism in elementary school, and she was not calling about autism, she was calling for rental assistance. She was actually being threatened with eviction because she had, it makes me sad thinking about this, sorry. Her son they'd been called to pick her kid up so many times that she had lost so much revenue from her hourly paid job that I think she had lost her job, and she could not make her rent and was being threatened with eviction. And so this was all because of this early pickups situation where kids are called, parents are called, come get your kid. And like Jolene Sanders said, a lot of times it's not, it could be anything. It could be like Johnny didn't want to participate. He was being loud over here. And so this happens so much to families of kids with autism. It's shocking how much it happens. They're losing out on social, social times. They're missing out educational times. It's incredibly negatively impacting to the entire family. And also, as Jolene mentioned, kids with autism a lot of times realize, like, hey, if I just act up, my teacher's going to call my mom, I get to go home. And so it's also not even a good disciplinary practice. I mean, it's horrible for so many reasons. So I'm very thankful to the representative for refiling this. We've supported it every session, and I hope this year it will pass. Thank you.
Jackie, may I call you by your first name?
Yes.
Let me ask you something. These are children that are not acting out because of they're not fighting or carrying on like that, but they have these other problems, disabilities.
Yes, yes.
And what I think you're saying also, we may not be equipping our schools with a department within it that can deal with these children. And I hate to use this as an example, but it's an experience I had. In the 1999, I had an opportunity to go to Taipei, Taiwan. So while I was there, they carried me to an elementary school. And in that elementary school, Representative Allison, they had a whole department, a better word would be like social workers, several people, a whole department. So if a kid was having a bad day, like some of these children that you're describing to the committee today, these persons would be allowed to go to that department and talk to someone who were experienced with dealing with those children while they were at school. And then after they got them calmed down and readjusted for whatever problem they were having, they can go back to class. Maybe we should look at something like that.
Yes, and some schools do things like that, like some schools have like a special, their special education case manager would have like an area with like beanbags and fidget toys, or ideally the gen ed teacher that is supporting them would have training on like how to work with kids with autism and how to preemptively work on that behavior in the first place. So there's definitely more support and room for education kind of on how to manage behaviors in general as well.
Well, I'm hoping that we started looking at things rather than in a silo, but more broadly, and see what kind of services we can integrate within a school setting that would make the school more enjoyable for these children who would be attending.
Yes.
That's the reason why I gave that experience.
Yes, definitely.
Chairman King, let me announce that Chairman Landgraf is now present. Go ahead.
Thank you. I think this question is probably best directed maybe at Ms. Sanders or anybody, and maybe another witness that hadn't come up yet. But anyway, so in this scenario, for whatever reason, the teacher or administrator possibly calls a parent and says, "Hey, you need to come pick up your child. They're not doing well today. They're acting out." Is that what you're talking about here?
Yes.
Okay, and so what happens to this teacher or the school's ADA for that particular day?
It's a great question. A lot of these calls happen after 10 a.m.
That's what I would assume.
Yes. And let's be really clear that like Jackie was mentioning, sometimes it's a really easy fix. It's just a quick redirection. It's, and I think that's where parents who know their kids better than anybody, have a really important role to play. Like, I know my son, I have an 18-year-old with autism. I know that, like, there are certain key words, there are certain, ways that I can speak with him. There are certain things that I can do to, help him calm down. And so I think that partnership between the school and the family is really important too. I will say this is not just unique to Texas. There have been other states. Oregon is a big example. There have been class action lawsuits, DOJ investigations. I want to see Texas take the lead on this and get it right, and set an example, and eliminate this practice for kids.
Just identify yourself.
Oh, yes, ma'am. Anita Scott with Texas Homeschool Coalition. I will say that I'm sure it's probably very traceable, very trackable, that the number of times that a teacher will call a parent is seasonal. And it's typically around when there's about to be an extensive school break. And the teacher's threshold for what they have been able to deal with on a basis becomes shorter and shorter, because they're looking forward to being out of the school building. So perhaps what little Johnny was able to get away with in August and September, the teacher doesn't have the threshold for that in November and December, and starts to consistently make phone calls because the teacher is looking forward to being out of the building. And so as a former administrator, I used to ask my teachers, well, how long has Johnny been doing this? And they'll say, oh my gosh, since the beginning of the school. And I would say, well, why is it such a big deal now? Is because the teacher had crossed that threshold of what they felt they could put up with in the classroom.
And so when they cross that threshold of what they can put up in that classroom, what do you suggest to do?
I love what Chairwoman Thompson said about having a department and allocating resources to a department where there are trained professionals who can help little Johnny calm down in order for little Johnny to stay in the building and receive and procure all the academics that he needs to.
Can I add just very quickly?
Just identify yourself.
Yeah, you just have to be recognized before you can.
Sure. Jolene Sanders at Coalition of Texans with Disabilities. Just to add on to that, Dr. Allen had an excellent bill last session that passed. It's a unicorn of a bill unanimously. And, that has to do with when behavior intervention plans need to be reevaluated. And in instances where a student has an individualized education plan, maybe they don't have a behavior intervention plan. Maybe they do, and it needs to be revised. So in addition to having, support on campus or at the district level, having this department, like Chair Thompson was describing, there are mechanisms, and there's a process to go back and say, okay, Johnny's been sent home every week since the beginning of the school year. We need to go look at his IEP and see what's working, what's not working. Do we need to adjust goals? Do we need to revise accommodations or modifications? Do we even have this kid properly identified? Because that can make all the difference in the world. So, that's the solution. Instead of, I feel like so many parents feel like they've just written my kid off too quickly. And we know that there's a better way.
Thank you.
Any further questions? Thank you. You've been a wonderful panel.
Thank you so much. Thank you.
Sabrina Gonzalez.
Okay.
Sabrina, we noticed you with the Texas Council for Developmental Disabilities, and you are neutral on the bill. Is that correct?
Yes, that's correct.
You may proceed. 3 minutes.
Hello, my name is Sabrina Gonzalez Saucedo. I am a public policy analyst with the Texas Council for Developmental Disabilities. And y'all just had an amazing panel just talk about all of the really important things in this bill. I'm going to note that TCDD receives federal funding and therefore remains neutral on all proposed legislation. We serve as an educational resource to the legislature on the impact of policy on Texans with intellectual and developmental disabilities. With that being said, HB 773 is consistent with our missions, values, and guiding principles. I will note that a really important part of this is the fact that these early pickups and school-initiated shortened school days are undocumented, and that's what's one of the biggest problems with this. As was mentioned earlier, for students with individualized education programs or served under special education, there's a process for looking at a student's behavior intervention plan, if they have one in place, if it needs to be adjusted, especially when there are cumulative days of exclusionary discipline. The Individuals with Disabilities Education Act has a process for requiring school districts to look at that student's behavior and conduct a manifestation determination review. Because these shortened school days aren't being documented, a lot of the times these MDRs aren't being done, and so a student doesn't end up getting the root of that cause understood as to why they were being sent home or why they were being called. When these MDRs aren't being recorded, they become more frequent, and utilizing parent pickups may mean that a school is not asking the important questions to figure out the underlying needs of students and their families, leaving the student at more risk for punishment, missed classroom and socialization time, and poor academic outcomes. In the end, these early pickups are then undocumented, the student's needs go unaddressed, and the cycle continues. HB 773, as stated, is consistent with our mission, guiding principles, and public policy priorities, and I'd be happy to give any additional information or answer any questions.
Members, are there any questions? Thank you so much.
Thank you.
Is there anyone else here wishing to testify on, for, or against House Bill 773? If not, the testimony on House Bill 773 is now closed, and the chair recognizes Representative Allen to close on her bill.
Once again, I want to thank those persons who came to testify on the bill. They did a wonderful job, and I think this time we'll do something about this. We need to help children and help parents. I close.
Members, are there any questions, Representative Allen? Members, the chair moves to withdraw the substitute and to leave House Bill 773 pending. Are there any objections? The chair hears none. The substitute is withdrawn and the bill would be left pending. The chair lays out House Bill 2361 and recognizes author Representative Price to explain the bill.
Thank you, Madam Chair, and thank you for allowing me the opportunity to bring up House Bill 2361. As you'll remember, back in 2019, we passed a bill that I authored, House Bill 19, that embedded local into regional ESCs, mental health, non-physician mental health professionals that we funded through all the regional local mental health authorities. And I appreciate Chair Thompson's joint authoring of that bill back in 2019. We've had success with that program, but one limitation has been that some of the regional service centers have had difficulty finding folks who are defined as non-professional mental health or non-physician mental health professionals, and that is a defined term. It includes a subset of certain licensed professionals. And so what this bill does is it allows some flexibility. It will allow local mental health authorities to hire a licensed master social worker and a licensed professional counselor associate licensed by the Texas State Board of Examiners and professional counselors to fill those positions. And they can only do that when the service center files a waiver and asks for permission that they can't fill it with the non-physician mental health professionals as defined in the bill that we passed in 2019. So if they need to, what this would do is allow some flexibility to go out and fill those slots to provide a mental health professional for those service centers. So districts who have trouble with counselors, who have districts, we have districts that have trouble hiring anybody as a family advocate or somebody as a connector. So putting somebody in the Regional Service Center is just an additional resource. And so what the bill does is just allow that flexibility. There was a committee substitute that was prepared, and I have it, but it's not before you today, but I'll bring it for you. It'll just have some clarifying intent language and revert the dates that you see back in the back part of the bill back to their original form. I'm happy to answer any questions the committee may have about this, and I would love the opportunity to close on the bill, Madam Chair.
Members, are there any questions?
No witnesses.
Is there anyone here wishing to testify on, for, or against House Bill 2361? If not, the testimony on House Bill 2361 is now closed, and the chair recognizes Representative Price to close on his bill.
Thank you, Madam Chair. I know of no opposition to this bill. I ask the committee's favorable consideration and would ask that you consider sending it to local on consent calendar.
Members, are there any questions of Representative Price? Thank you, Representative Price. Members, the chair moves to leave House Bill 2361 pending. Are there any objections? The chair hears none. The bill will be left pending. The chair lays out House Bill 185 and recognizes its author, Representative Mary Gonzalez, to explain the bill. The chair lays out Representative Chairman King offers the committee substitute. The chair lays out a committee substitute and recognizes Representative Gonzalez to explain the substitute as well as her bill.
Thank you, Chairwoman, and thank you, Vice Chair Hall. Really honored to speak to your committee. I love common sense pieces of legislation. This piece of legislation literally takes the recommendations from the Public Education Interim Report and makes it into a bill. We know that we have kids who are chronically absent. This bill does three things. One, it adds it defines chronically absent. Two, it adds that to the at-risk category. And three, it creates a report. These were all the four recommendations that the Public Ed Committee, like Representative Allison or Representative Lozano, you signed that we should do. So we're just actually actualizing the recommendations that the committee made during the interim to solve chronic absenteeism, which we know has a domino effect on kids, not just on their grades, but their health, their mental health, et cetera. And we have a wonderful witness who will talk about the impact of chronic absenteeism. And with that, Chairwoman, I would like to reserve the right to close.
Members, are there any questions, Representative Gonzalez? Thank you. All right, Mandy Kimball, we're down to you now. Mandy, we show that you are the Director of Public Policy and Government Affairs for Children at Risk, and you're for the bill.
Yes, ma'am.
You may proceed.
Thank you. Mandy Kimball with Children at Risk. Thank you for your time, Chairwoman Thompson, Vice Chair Hull. Common sense. It is a common sense bill. We know that children who are chronically absent are at risk of dropping out. We know that children who are chronically absent are less likely to graduate. And here recently, chronic absenteeism has been a problem for years, but the pandemic and then the concern for youth safety has increased the awareness of the problem. And Texas cannot effectively implement strategies and assist chronically absent students without statewide definition, data, and appropriate supports. Children at Risk did a open records request and to look at chronic absenteeism, which you should have data specific to your district. Statewide chronic absenteeism averaged at 15% in 2021, 2022, and it varies dramatically by region. More than 760,000 students missed at least 1/10 of their instructional time in 2021. The Corpus Christi and Midland regions have some of the highest rates in Texas, while El Paso and Enberg are areas of the lowest rates. When we look at populations, different populations, pregnant students have the highest rates of chronic absenteeism, desegregated by race and ethnicity. Black and Hispanic students are above the state average. And the overall rate of chronic absenteeism for special ed students is 20%. Chronic absenteeism has increased 3 percentage points from the 2020-21 school year and the 2021-2022 school year. There are many contributing factors around chronic absenteeism, and I hope I know that I've spoken with many of your offices. What's the difference between chronic absenteeism and truancy? And there are differences. The factors that contribute to chronic absenteeism is illness of a student, a relative, lack of engagement in school, lack of transportation to be able to go to school, involvement in childcare or child welfare and juvenile justice, and then living situations, homelessness, lack of health care, trauma, negative experiences such as bullying. So it's not just a child not coming to school or choosing to be truant. So thank you very much, and I'm happy to answer any questions you might have.
Members, are there any questions? Thank you very much. Is there anyone else here wishing to testify on, for, or against House Bill 185? If not, the testimony on House Bill 185 is now closed, and the chair recognizes Representative Gonzalez to close on her bill.
Thank you, Chairman Thompson. And Chairman Dutton, you missed my layout, but these were, this bill is all the committee the Public Education Committee interim report. So we just took the recommendations that our committee made, put them into a bill, and so we can just, take the work we do during the interim seriously. A pretty common sense bill, have a domino effect of wonderful benefits, and for that, I ask for favorable consideration and consideration to go to local and consent.
Members, are there any questions? Thank you very much. Members, the chair moves to withdraw the substitute and leave House Bill 185 pending. Are there any objections? The chair hears none. The substitute is withdrawn and the bill will be left pending. The chair lays out House Bill 2976 and recognizes Author Chairman Guillen to explain the bill.
Thank you, Madam Chair. Members, it's 2976, right? Members, the right to bear arms is one of the fundamental rights of our society, but rights also bring with them responsibilities. Our founding fathers saw firearms in the hands of our citizens as tools to protect our democracy, but these tools should be handled with care. HB 2976 will allow high schools to offer an elective course on firearms safety to develop the skills and care necessary to responsibly handle firearms. The bill directs the State Board of Education to develop a firearms safety course to focus on accident prevention, promote the safety and protection of students, emphasize how students should respond when encountering a firearm, and include firearms safety information contained in the Texas Parks and Wildlife Department's Hunter Education course. House Bill 2976 would make these firearm safety courses available as electives to public high schools in an in-classroom as well as virtual format. In addition, the virtual version of the course would also be offered free of charge on the website of the TA, the TPWD, and DPS, making firearms safety awareness accessible to all Texans. And I can help answer any questions if y'all have any.
Members, are there any questions? Thank you. We have one witness, Steve Hall.
Madam Chair.
Mr. Hall, we show you with the Parks and Wildlife Department, and you are neutral on the bill. Is that correct?
Correct.
You may proceed. 3 minutes.
Madam Chair, members of the committee, my name is Steve Hall. I'm the Hunter Education Coordinator with Texas Parks and Wildlife Department. Been involved with that program for 35 years and watched the accident reduction come way down with the program. I can answer any questions that you may have.
Members, are there any questions? Thank you. Chair recognizes Representative Landon Johnson is now present. Thank you. Is there anyone else here wishing to testify on, for, or against House Bill 2976? If not, the testimony on House Bill 2976 is now closed, and the chair recognizes Chairman Guillen to close on his bill.
Thank you, Madam Chair. If there's no further questions, I'd ask for your favorable consideration. I close.
Members, are there any questions of Representative Guillen? The the chair moves to leave House Bill 2976 pending. Are there any objections? The chair hears none. House Bill 2976 will be left pending. The chair lays out House Bill 3649 and recognizes author, Chairman Guillen, to explain the bill.
Thank you, Madam Chair. The Texas School Safety Center is responsible for...
I'm sorry, I made a mistake in pronouncing. House Bill 3648. Thank you.
The Texas School Safety Center is responsible for overseeing the development of safety training programs, security audit procedures and policies, and procedures for threat assessment teams in Texas schools. Currently, the board of directors for the center includes a diverse group of members such as a juvenile court judge, a school district board member, and a school teacher. However, there's not specific representation for special ed on the board, and this omission means that the safety needs of students with disabilities may not be fully considered in the development of safety protocols and procedures. For example, students with mobility, auditory, sensory, visual, and behavioral challenges may experience alerts, drills, and safety mechanisms differently and may require special accommodations during these emergencies. House Bill 3648 simply adds a special ed director to the board of directors for the Texas School Safety Center, someone who can provide valuable insight into preventative measures to help strengthen safety systems and help keep special ed students safe during these emergencies. I can help answer any questions if you have.
Are there any questions? Okay, members, we have one witness, Andre Chevalier, and I call it Chevalier. Andre, we see you, we show you as representing the Texas Council of Administrators of Special Education, and you are for the bill, is that correct?
Yes.
You may proceed, you have 3 minutes.
Thank you. Dr. Andrea Chevalier with TCASE, and want to thank Representative Guillen so much for this bill. I think as we are experiencing a change in the protocols and the policies and procedures in public schools related to safety, we have to make sure that students with disabilities and staff with disabilities as well are not an afterthought as we're planning. And so Representative Guillen mentioned that some students with mobility needs or auditory visual needs will experience drills differently. That's one example. There's also the example of students who may be transitioning from the gen ed classroom to a different room to receive therapy, like speech therapy. Before, we had automatically locking doors and doors that stayed locked all the time. A lot of times those older kids and older elementary and above would make that walk to their therapy room by themselves. Now they're having to be walked by a staff member. Sometimes it's the person who's providing the therapy. So there's just little kind of special considerations that have to be taken into account, and I think having a special education director on the School Safety Center Board will help ensure, as we are developing even more policies and guidelines with some of the other school safety bills that we have, make sure that none of the special perspectives are left out in that planning process. Thank you.
Members, are there any questions? Thank you very much.
Thank you.
Is there anyone else here wishing to testify on, for, or against House Bill 3648? If not, testimony on House Bill 3648 is now closed, and the chair recognizes Chairman Guillen to close on his bill.
Thank you, Madam Chair. If there's no further questions, I'd ask for your favorable consideration, and I close.
Members, the chair moves to leave House Bill 3648 pending. Are there any objections? The chair hears none. House Bill 3648 will be left pending. The chair lays out House Bill 2812 and recognizes author Chairman Burns to explain the bill.
Thank you, Madam Chairman, members.
Chairman Burns, let me allow Vice Chair Hull to offer the committee substitute. The chair lays out the committee substitute and recognizes Chairman Burns to explain the committee substitute along with the bill.
Thank you very much. Appreciate that. Just to give you a quick background, under current law, a qualified handgun instructor certified to provide school safety training may provide such training to an employee of a public school or an open enrollment charter school as long as that school employee has a license to carry and receives written permission from their district. However, under current law, the same certified handgun instructor may not provide that same training to an individual with the same credentials that I just mentioned if they are employed by a private school, because it's not expressly mentioned in statute. So I have a constituent that's currently licensed to offer training for the Guardian program to public schools and charter schools, yet he cannot offer that same training to private schools. Private schools are probably doing this training completely unaware that they may be breaking the law, and so we're simply making this change to make it the same for everybody. The only difference between the committee substitute and the file bill is that the committee substitute allows for a corrected definition of private schools so that everybody can receive this training. At this time, I'd be happy to answer any questions you may have.
Members, are there any questions? Thank you. Michael Belsick, Wesley Verdale, Laura Colangelo. And I may mispronounce the last name. Who are we missing? You are?
Mike Belsick.
Okay, hold on.
And I know Wes Verdal was here.
Okay, let's get to the next one. Jennifer Allman. Michael Belsick, I show that you are representing yourself and you're for the bill. Is that correct?
Correct.
You have 3 minutes.
Every American, Democrat or Republican, rich or poor, mourns the victims of criminal violence, especially when children are involved. We are all united in our grief. Our difference focus on how to prevent children becomes victims in the future. That's where we differ. I grew up in the 50s and 60s. Back then, guns per capita were about the same as they are today, and type of guns back then were nearly the same as today as well. However, mass shootings were extremely rare back then. While there has always been murder, the murder rate was also less back then. So what has changed? People have changed. Today's society is completely different, and sadly, it's my opinion, getting worse. My point is that preventing any prevention strategy that focuses only on guns is doomed to fail. Criminals will always find a way to obtain guns, sort of same with any mentally ill people. If society is incapable of preventing over 100,000 fentanyl deaths per year, then preventing gun deaths by attempting to limit guns will only keep guns out of the hands of law-abiding citizens and not affecting criminals at all. Additionally, society seems to be increasing the percentage of people with mental health issues. The only ways to safeguard our children on schools, which is our priority, is by fortifying the property and have trained teachers, administrators, custodians, or people there specifically for that purpose to have firearms. It might be sad to do it, but in reality, it is the only viable solution. So thank you.
Members, are there any questions? Thank you. Laura?
Colangelo.
Thank you. And I show that you are representing the Texas Private School Association and yourself, and you're for the bill.
Correct.
Go ahead.
Thank you, Madam Chair and Committee. My name is Laura Colangelo, the Executive Director of the Texas Private Schools Association. We represent the 920 private accredited nonprofit schools in Texas, serving approximately 270,000 students. We are testifying for HB 2812, and we thank Chairman Burns for his commitment to keeping children safe in all school environments. What this bill does is correct an oversight in the government code, section 411.1901, where it's explicit that qualified handgun instructors may provide school safety training to employees in district and charter schools, but did not include private schools on that list. Private schools are included in statute and may participate in the school marshal and guardian programs, but the handgun instructors have been operating in a bit of no man's land in terms of who they can train and who they can't. So this bill just corrects that. We at TPASA they do not endorse any one school safety strategy. We simply want our private schools to know about the school safety options available to them and be able to easily implement whatever they choose to protect the school community. That was exciting. It was exactly 1 week ago that we learned of the tragedy in Nashville that involving a private school. We knew that we were not immune to this kind of violence and horror, but we ask that you help us as we move forward in our efforts to secure our campuses and keep our students and staff safe. Thank you.
Members, are there any questions? Thank you. Jennifer Allman, I show you are representing the Texas Catholic Conference of Bishops, and you are for the bill.
Yes.
You may proceed.
My name is Jennifer Allman. I'm the Executive Director of a Texas Catholic Conference of Bishops, and we are in support of HB 2812. And we thank Representative Burns for bringing this bill and for the committee sub with the amended definition of private school. We appreciate that change. I'm here because on January 30th of this year, we had a near miss at one of our Catholic schools in the Diocese of Beaumont in front of St. Anthony's Catholic School. A man had been parked in front of the school for several days, looked suspicious, was acting suspicious, but there was no reason that the police could intervene. Finally, he had a traffic violation while pulling out of a parking spot, and they were able to intervene, and in his car was an AR-15 and a car full of ammunition, hundreds and hundreds of rounds of ammunition for that AR-15. He was arrested and apprehended. The police acted as best they could and as swiftly as they could. But Sister Bernadette, the principal, had certainly not received any active shooter training, and the school had not been aware that they would need that level of protection at their school in Beaumont, Texas. But today, our Catholic schools are exploring all available options for school safety, and as this committee is looking at this issue throughout the session, we hope that you'll remember to keep private schools in the list of options. Just as Laura stated, it's not that we want you to mandate anything on our schools, but we would like to have access to all the available training and options public schools have, because we want every single child in Texas protected. The Bishop of Beaumont specifically said, when you have the opportunity to go tell the committee what almost happened and didn't, please do. Because we commend the law enforcement for their patiently waiting for a violation that enabled them to arrest this man. And we praise God that the children are safe today. So we encourage you to pass this bill to give us another option to protect our children.
Members, are there any questions? Yeah. Chairman Dutton.
Thank you. I guess I'm struggling with something, but is it your opinion that you could not now, under the law, have a qualified handgun instructor certified to teach?
It's our opinion that the law lacks clarity on that, and that the explicit protection offered in this bill would be an improved situation for choosing that option.
So you think it's unclear as to whether or not you could, but there's nothing in it that would...
There's nothing that prohibits it, but because it explicitly lists public schools and charter schools, we believe it should explicitly list private schools as well, and that's what the bill seeks to do.
Because that's what I was thinking, because we do that in a number of instances in terms of in terms of traditional public schools and charter schools, where they're mentioned in particular, but they don't mention private schools, but private schools can choose to do what they like almost.
Typically, that's in relation to a regulation where we would choose a policy. And the difference in this and those situations is this is to ensure we have access to a training. And so anytime it gives us access, we like to be listed. So there's lots of similar legislation this session on other topics where we're saying include us in this instance, but not in other instances.
But you're not, under the current law, excluded from doing it.
We don't believe that we're excluded from doing it. That's not our analysis today, but we haven't actively participated in it in much of the state.
Any further questions? Thank you very much.
Thank you.
I want to show that Wesley Verdell had registered to vote for the bill, and he represented Gun Owners of America and did not testify. Is there anyone else here wishing to testify on, for, or against House Bill 2812? If not, the testimony on House Bill 2812 is now closed, and the chair recognizes Chairman Burns to close on his bill.
Thank you, Madam Chairman. Again, thank you for your attention. I think this is just making sure all options are on the table for everyone. And if you have any questions, I'm happy to answer them. Otherwise, I would close and ask for your favorable consideration.
Members, are there any questions? Thank you very much.
Thank you.
Members, the chair moves to withdraw the substitute and leave House Bill 2812 pending. Are there any objections? The chair hears none. The substitute is withdrawn, and the bill will be left pending. The chair lays out House Bill 2126 and recognizes Author Representative Goodwin to explain the bill, her bill.
Thank you, Chairwoman Thompson and members. House Bill 2126 is all about transparency and accessibility of data about disciplinary actions in our public schools, as well as information to parents about corporal punishment in public schools. This bill passed the House last session. When it comes to discipline in our schools, are Black and brown children disciplined more often? And is their discipline more heavy-handed than that of white children? The answer to that and other similar questions should be fairly easy to find. Public schools are required to submit information about disciplinary actions to the Texas Education Agency, TEA, and there's no reason this information can't be shared with parents who might want to know. But right now, digging through the TEA website to find the relevant data is a frustrating and virtually impossible task. House Bill 2126 makes use of data from the Public Education Information Management System, otherwise known as PIEMS, which schools are already required to report. Each school district includes in the PIEMS report the total number of disaggregated by gender, race, and special education status of incidents of corporal punishment, reports to local law enforcement, suspensions, changes in school placement, expulsions, arrests, and referrals to truancy court. TEA would make the results of both individual districts' discipline along with statewide totals available to the districts. Each district would then provide access to the annual report that includes the data for each individual campus, the district as a whole, and the entire state. That report would need to be easily readable and would need to be shared on the school's website. Additionally, a copy of the report would be emailed to each student's parent or guardian. Regarding corporal punishment, the bill ensures parents know the school's policy and the parents' rights when it comes to this type of punishment. I plan to have a committee substitute, but it's not available from Legislative Council yet, but the only change it would make is to add physical restraint of a student to the list of disciplinary actions on the report. Chairwoman and colleagues, House Bill 2126 is a vital step forward in promoting transparency, accountability, and communication between our schools and parents or guardians. As I stated, this bill passed the House last session. This bill could have a lasting positive impact on the safety, mental health, and well-being of our students. I'm happy to take any questions.
Members, are there any questions? Chairman Dutton.
Thank you. Yeah, I remember this bill from last time, and one of the things I wondered about it was, should we somehow or another identify the teachers who are sending these kids to these disciplinary schools? And let me tell you why I'm asking, because one of the things we might begin to realize is that some teachers may need a better classroom management technique than others. And if the same teacher is the one that's engaging in this conduct, we ought to maybe identify that, or at least somehow or another identify it so that we could do something about it.
I mean, you make a very good point. I think that just by having this data being easily readable, maybe that would become apparent that this particular school campus has more referrals or what have you than other schools, and then maybe the principal will take notice and dive deeper.
And to see what the teacher is. Okay, thank you. I like the bill. I just thought about, if we really want to ensure that students are treated equally, fairly, one of the things we might look at is not sort of helping the student as much as helping the teacher.
No, I agree. That's a good point. Thank you.
Thank you.
Members, are there any other questions? Thank you. Angel Carroll, Cindy Decker, Sampradhansa Kondara. Okay, Kondara, I'm going to let you start first. I show that you are representing Asian Texas for Justice and yourself, and you for the bill. And would you pronounce your name, because I don't think I got it correct.
Yes, ma'am. It's Samprathana Kongdara, but I go by Akila.
Can you go slower?
It's Samprathana Kongdara, and I go by Akila. Thank you, Chairwoman Thompson and the members of the Youth Health and Safety Committee. My name again is Akila Kongdara, and I'm testifying on behalf of Asian Texans for Justice, or ATJ. I am testifying in support of HB 2126. ATJ is a 501c3 organization that connects the 1.9 million Asian American and Pacific Islanders across the state to civic action. I wanted to emphasize the importance of this bill on the AAPI community. This past summer, our organization launched the first ever voter research poll on the Texas AAPI community. We found that about 44% of the AAPI population in Texas are immigrants, and a third of the Asian Texans are not English proficient. Nonetheless, general knowledge of corporal punishment policies in public schools is low for Asian Texans, furthering the necessity to mandate notices issued by schools and districts. Texans deserve to be informed about their children's education and the discipline they may face. Corporal punishment can open up the wounds of intergenerational trauma and abuse, leading to an array of negative effects on individuals' development and mental health. Amongst the AAPI community, mental health continues to be an ongoing issue. According to the CDC, suicide is the leading cause of death for AAPIs between the ages of 15 and 24. By making corporal punishment information accessible, we are allowing parents to be informed, we are allowing parents to make informed decisions. Additionally, the AAPI community is vast, with over 60 ethnic groups speaking over 100 languages and the largest economic gaps between ethnic groups. Our experiences are different based on our identities, and as a Lao American born and raised in the Panhandle, I can attest that my experiences differ from one of my East Asian counterparts from any of the Metroplex areas. Our families and communities face various hardships that influence behavior and discipline. Data disaggregation allows for better understanding of the breadth of corporal punishment. HB 2126 is a stepping stone to giving parents an informed choice in their children's discipline. Thank you.
Members, are there any questions? Thank you. Cindy Decker, I show that you are representing yourself and you are for the bill.
Yes, thank you. Thank you, Chairman, and thank you, committee, again, for having me here. My name is Cindy Decker. I'm the mother of 3 children and an advocate for my kids. I'm representing myself in favor of this bill. And I want to thank Representative Goodwin for bringing the bill back up. I think it's important to have the data in front of us to understand, and as Representative Dutton mentioned, so that we can narrow down what areas, what districts, what schools specifically, maybe what teachers, to give them the right tools to helping our kids. My youngest child is an 11-year-old boy with a disability, with autism spectrum disorder. He does not like touch. And therefore adding restraints to corporal punishment should be one of them. At 11 years of age, I still have to ask my son if I can give him a hug. And when I ask, buddy, can I give you a hug? He'll lean in, touch his head to my shoulder, and walk away. That's as much as he can handle for touch. So you can imagine if you actually add a squeeze, or if you add a restraint, which at times in his younger years, he was actually restrained to chairs with his hands behind his back, his feet underneath him to help him contain his behavior. And the challenge with that is that it escalated his behavior because, again, he can't handle touch. Therefore, restraints should be a corporal punishment in this bill as well, but also informing the parents. Again, I had 2 older children who graduated now out of the public education system, and I had no idea that corporal punishment was actually still allowed in schools in this decade and in this era until I had a child with disabilities in the public school system. So I ask you please to go for bill, move forward so that we can get more information, more data, and recording for the parents.
Members, are there any questions? Thank you. Ann? Angel?
Angel.
Angel?
Yes, ma'am.
Carol? We see that you are representing Measure, and you are for the bill.
Yes, ma'am, I am. You all have some one-pagers about the bill and some data. So the measure bill, HB 2126, we brought to Representative Goodwin last session, which we thank her for that and her work there. Through our Innocence Initiative, we protect Black girls, and the data shows that Black girls and Black boys are disproportionately affected by disciplinary action in our schools, and that's what this bill does. Measure is a Black woman-led research organization, and we mobilize the community. My goal, why we're here with this bill, is we want to give the data to the community and the parents so that they can advocate for their children and mobilize. And that's the heart of this bill. We're not asking TEA to do anything that they're not already doing. We just want it in a caregiver-friendly way that they can read as researchers. It's hard for me to get that data and to find it through the system. I can't imagine how difficult it is for a parent, and having those resources to say, you know, my child is in this school district, my child is in this school, and there's an issue, but where do I find that data? Because that's all that, quite frankly, I feel like those at the top care about. And again, just getting that information to them is extremely important to us. If you have any questions, please let me know, and my contact information's on that one pager as well.
Members, are there any questions? Thank you very much.
Thank you.
Thank you. Sabrina Gonzalez. Sabrina, we show that you are representing the Texas Council for Developmental Disabilities, and you are neutral on the bill. Is that correct?
Yes.
You may proceed. You have 3 minutes.
Hello, everyone. My name is Sabrina Gonzalez Saucedo. I'm a public policy analyst with the Texas Council for Developmental Disabilities, and we're testifying on the bill, again, because of our federal funding. We serve as an educational resource to the legislature on all policy that impacts students and people, Texans, with intellectual and developmental disabilities. As Representative Goodwin stated before, this bill is all about transparency. It's about making sure that parents are aware of the corporal punishment policies that schools currently have in place, which many have no idea that corporal punishment still is even allowed to be used in schools. So this allows parents to know exactly what the school's policies are regarding corporal punishment. In addition to that, it allows parents and school leaders to be aware of the disciplinary actions being taken at school and the data disaggregated, which is really important because, as we've talked about in this committee, often students with disabilities and students of color particularly are impacted disproportionately by school discipline measures. Adding disciplinary data to this reported educational data system will provide TEA and school districts with an opportunity to periodically review and, if necessary, revise their disciplinary practices. This is an important first step in addressing the leading factors to the school-to-prison pipeline, which impacts students with disabilities disproportionately. We thank Representative Goodwin and her office for a language in the proposed committee substitute that will include the action of physical restraints to be included in this reported data. This is because physical restraint, although it's not a disciplinary measure, is often used unlawfully as a disciplinary measure. Restraint, as Representative Hull is nodding along, knows that it is meant to be used as an emergency intervention, to be used in the most serious cases in which a student poses a serious imminent threat of harm to themselves or others. However, this is most often used against students with disabilities in cases where it's not. So we, again, thank the representative for bringing this bill forward. We believe that HB 2126 is one step towards increasing transparency and tracking the use of disciplinary measures against students with schools. It's students in schools. I'd be happy to take any questions.
Chairman Dutton.
Thank you. Why do you think black and brown kids get disproportionately disciplined?
That's a great question. I don't know that I have an answer that would lead to the depth of what the answer to that is.
So you don't have an opinion about that one way or the other?
I do not have an answer for you in my capacity.
How do we fix the problem?
I think it's through bills like this. It's through making sure that data is accessible to be able to look at just how deep the problem is and talking about the roots of these issues.
Okay, thank you.
Any further questions, members? Thank you, Sabrina.
Thank you.
Is there anyone else here wishing to testify on, for, or against House Bill 2126? If not, the testimony on House Bill 2126 is now closed, and the chair recognizes Representative Goodwin to close on her bill.
Thank you, Chairwoman and members, and I appreciate the witnesses who came here today to speak to how this bill would be helpful, and I hope that you will give it favorable consideration. With that, I close.
Members, are there any questions? Thank you. Members, the chair moves to leave House Bill 2126 pending. Are there any objections? The chair hears none. The bill will be left pending. The chair lays out House Bill 3642 and recognizes author Representative Tellerico to explain the bill.
Thank you, Madam Chair. Thank you, committee members. There's been a lot of discussion in this hearing already about behavior problems in schools and how that relates to school safety. This bill, HB 3642, I think gives us more resources and training for educators in our classrooms to deal with behavior problems before they escalate to become safety issues on campus. So this bill is really about the lost art of classroom management. And any educator will tell you that that's a critical part of running a classroom. You've got to be an expert in your content, in your pedagogy, and lesson planning, and instructional design, and paperwork, and relationship building. But all of that doesn't really matter if you don't have control of your classroom. If you are not laying out clear rules, if you're not practicing those rules, if you don't have clear consequences when someone violates those rules, and if you aren't learning the techniques that are proven in managing a successful classroom. So what this bill would do would be to allow school districts to use the school safety allotment funds to provide teachers with classroom management training that equips teachers with the tools necessary to manage challenging student behavior. And I think the goal would be that these behavior issues would be addressed on the front end before they become safety concerns on our campus. With that, I'd be happy to answer any questions and, of course, reserve my right to close.
Members, are there any questions? Thank you. Kimler Sayers, Sabrina Gonzalez. Kimberly Sayers, we show you as representative of communities and schools of San Antonio, and you are for the bill.
Yes, I am.
You have 3 minutes.
Thank you. Good afternoon. My name is Kimberly Sayers, and I am a licensed professional counselor supervisor and currently serve as the Director of Clinical Programs for communities and schools in San Antonio. And I'm here to speak on the importance of keeping mental health funding as a permissible use of school safety and security, as well as the increased importance in designating a certain portion of safety and security money specifically for mental health supports in our schools. I'd like to highlight one of our programs that I oversee called the Base Campus Program that is privately funded, but it has provided essential mental health services in 2 school districts in San Antonio for the past 5 years already. I want to showcase the effectiveness of the Base Campus Program in providing a positive and safe school environment, provides mental health supports on the campus, and especially classroom management supports in our schools, which are all needs highlighted by this current bill. So as you know, funds allocated by this bill must be used to improve school safety and security, and it states that funds can be used in the 3 areas: securing school facilities, providing security personnel for the district, and school safety and security and training, as well as planning. Securing our buildings is very important, but the most precious and valuable resource in any school are the students and the educators on the campus. Our base campus program has been designed to provide mental health support, staff training, educator training, and coaching, as well as parent education and classroom management support on the school campuses that we serve. Several sections of the bill advocate for providing licensed mental health personnel, counselors, and social workers that provide behavioral health services, providing programs related to suicide prevention, intervention, and postvention, as well as for individuals trained in restorative discipline and restorative justice practices on school campuses. And our base campus program model utilizes a licensed professional counselor to provide a variety of training opportunities to support our educators in the schools. Some of these programs include training on the restorative discipline, restorative justice practices, training on helping educators identify and recognize early warning signs of mental health, helping them recognize and communicate with parents about suicide ideation in students, and also providing training on adverse childhood experiences and how students' past trauma may affect their education. In Section 3C, Representative Tallarico has added Part 5, which asks for schools to provide professional development opportunities for educators regarding classroom behavior management. And our basic campus program has worked with the districts that we serve so that when teachers attend our trainings, they do receive credit for attending those trainings as part of their, what in our district called teacher choice hours. So that helps them utilize the skills they learn in our trainings to help them coordinate better behavior management in their classrooms. So over the past 5 years of programming, we've also utilized independent research evaluations of the base campus program, and find that teachers, students, parents, administrators, and other school staff see the need for mental health support, and they respond positively to the right supports at the right time by the right program. So please help us emphasize the importance of mental health services in our schools by designating funding specifically for mental health supports through this bill.
Members, are there any questions of Mrs. Kimball Sayers? Thank you very much. Sabrina Gonzalez, we show you as representative of the Texas Council for Developmental Disabilities, and you are neutral on the bill.
Yes.
You may proceed.
Hello, Chair Thompson and committee members. Thank you for the opportunity to provide comments on HB 3642. HB 3642 would give school districts the authority to use the school safety allotment to provide professional development opportunities to educators on classroom behavioral management. This would increase safety by equipping educators with the tools to respond to challenging behaviors in the classroom. The benefits to effective classroom management extend to academic-related outcomes, including decreasing disruptive behaviors and increasing academic learning and engagement. This is in line with the purpose of the school safety allotment, which is to help fund equipment, programs, and training related to school safety and security. TCDD has already been in contact with the legislative author and has recommended a small modification to the language of the bill, replacing the phrase classroom behavioral management with the phrase positive behavior interventions and supports. This would more accurately reflect the goal of the bill and represent best practice when teachers are addressing challenging student behavior. As such, TCDD finds the aims of the bill to be consistent with our mission, guiding principles, and public policy priorities. And I'd be happy to answer any questions.
Members, are there any questions? Thank you very much.
Thank you.
Is there anyone else here wishing to testify on, for, or against House Bill 3642? If not, the testimony on House Bill 3642 is now closed, and the chair recognizes Representative Tallarico to close on his bill.
Thank you, Madam Chair, and thank you, committee members, for hearing this bill. I think it's especially important after the pandemic. Structure is really important for kids to be able to grow and thrive, and students went without that structure, and that's why we've seen these escalating misbehaviors in classrooms, which I think you talk to any educator in any school and they'll tell you behavior is getting worse. We've got to get back to this lost art of how to manage a classroom, and there are techniques that you'll learn. You know, a simple one that I learned when I was an educator is something called behavior narration. So if I pretend like y'all were my students in this classroom, I would point out what I see as positive behaviors, and I would say, you know, Representative Hull, thank you for sitting straight in your chair and keeping your eyes on me. You know, thank you, Representative Landgraf, for taking notes. It's a great way. And then suddenly, Representative Johnson is hearing that positive behavior narration and starts to take notes and sit up straight in her chair, right? Not that she needs that, but that's an example. That's a simple technique that you would learn in a training like this to help keep your classroom under control and foster positive behaviors in your classroom. So,
Members, are there any questions? Chairman King? Thank you. No further questions. Members, the chair moves to leave House Bill 3642 pending. Are there any objections? The chair hears none. House Bill 3642 will be left pending. The chair lays out House Bill 4824 and recognized by Chairman Herrero and recognized Representative Johnson to explain the bill.
Good evening, Chairwoman Thompson, Vice Chair Hull. I'm happy to present this on behalf of Chair Herrero. House Bill 482 would allow the Board of Trustees of a school district to hire commissioned security officers to provide armed security services on a campus or district property. Currently, only law enforcement officers may carry firearms on school campuses or district property, which ties the hands of district administrators and the Board of Trustees when attempting to address school safety needs. Local police departments, constables, and sheriff departments are able to have staff present on campuses to ensure campus safety, yet this is particularly difficult for certain departments that may not have the resources or officers to provide adequate coverage. School districts are responsible for protecting our students, and by providing them the additional tool that would come with passage of this bill in their toolbox, we can ensure every option is available to keep school students safe. I know we have a few witnesses, and I'd ask for the right to reserve to close.
Members, are there any questions? Thank you. Chair calls Michael Belsick, Jason Hester, and Jeff Moore. I saw Mr. Belsick. See if he's coming in. Jeff Moore. I see that you are representing Assist, and you are representing yourself,
Yes, ma'am.
and you are for the bill.
Yes, ma'am. I
You
am.
may proceed.
Thank you, Madam Chair and members. My name is Jeff Moore, and I am the president of Assist. We are the largest security association here in Texas, composed of security company owners, private investigators, armored truck companies. I am here today in support of House Bill 4824. Chairman Herrero's bill will give Texas school districts the option to contract with private security companies regulated by the Texas Department of Public Safety to provide armed guards to help protect our school children. This bill removes an obstacle in the education code that states that only law enforcement officers may provide armed security in the Texas public schools currently. There are currently not enough law enforcement officers available to guard our schools. There are around 75,000 law enforcement officers in Texas actively, and currently around 150,000 private security officers. As you can see, this number's double law enforcement, which would allow more coverage of our schools, especially smaller school regions and districts. A level 2, 3, and 4 with all combined hours of training will have completed over 65 hours of training and also passes a state and federal background check. House Bill 4824 will require an additional 80 hours of special training to help protect our school children. If this bill passes, the many school districts, as stated before, will not only be able to provide security for their schools, but based on cost and budgets, in some cases would be able to provide twice the amount of security. In small districts that could never afford security before, will for the first time be able to afford having security. If another perk of having the private security involved in providing security is if a school resource officer negligently hurts someone, the taxpayers are responsible for that. In hiring privatized security and security companies, we must maintain liability insurance, workers' comp, in most cases, health insurance, and cover all expenses. Also, we do collect and remit sales tax to the state. Many of our officers are former military and former law enforcement. I can tell you most of the people that go through our training academy that I own are exactly that. So in closing, we are ready to stand up and provide security for the state of Texas and ready to do so at our private and public schools. Any questions?
Members, are there any questions? Thank you. Representative Allison?
Thank you, Madam Chair. You mentioned an 80-hour training, additional 80-hour training course.
Yes.
What's included in that 80 hours?
It's already been outlined, but it's going to be specific to active shooter training that's going to be specific to the safety of the school children, locking of the facilities, what to do in certain events. The training will be very specific in these type of incidents that are sadly occurring in our state.
Okay. First aid?
Yes. Well, this is still can be redefined in the 80 hours. We can add to it, additional things that, a committee or a board would want to add, but I don't have the specific on any first aid, but that could be added in.
Okay, thank you.
Any further questions? All right, Mr. Jason Hester, we see that you are representing the Texas Department of Public Safety and you are neutral on the bill.
Yes, ma'am.
You have 3 minutes.
Madam Chair, members, Jason Hester, Assistant Chief, Texas DPS. I oversee the Regulatory Services Program where the private security is housed. Here is a resource witness for any questions that the members may have.
Members, are there any questions? Thank you very much.
Thank you.
I want to show that Michael Belsick was representing himself and he was against the bill and he did not testify. Is there anyone else here wishing to testify on, for, or against House Bill 4824? If not, the testimony on House Bill 4824 is now closed, and the chair recognizes Representative Johnson to close on Representative Herrero's bill.
Thank you. On behalf of Chairman Herrero, I close and ask your favorable consideration.
Members, are there any questions? Members, the chair moves to leave House Bill 4824 pending. Are there any objections? The chair hears none. House Bill 4824 would be left pending. The chair lays out House Bill 2090 and recognizes its author, Representative Manuel, to explain the bill.
Good afternoon.
Representative Chairman Dutton offers up the committee substitute that is being laid out with your bill, and you can explain the substitute to us along with your bill.
Good afternoon, Chairwoman and members. Thank you so much for giving a freshman an opportunity to let me read to you my wonderful bill that I think you all will love. HB 2090 focuses on creating a safer community through education. This legislation proposes an education course designed to act as a preemptive measure against firearm violence and better preparing students in our communities for issues relating to family violence, sexual assault, mental health, self-defense tactics, and firearm safety education. People are becoming kind of desensitized and or have a lack of knowledge of understanding of what is family violence, domestic assault, and firearm safety. And this legislation looks forward to correct that. We can help stop the cycle of sexual assault, domestic violence by educating our students. And this would be a course that would be taught to 12th graders. And it would be an option for school districts to be able to implement this into the school district. It would not be forced upon them. And in this course, it would teach students what is sexual assault, domestic violence, what are mental health, where to look for firearm safety, and how to be able to reach out if you have these problems. In the committee sub, we have struck out statistics and replaced it with education to make sure that we are strictly sticking to an education background on this. What are each of these issues and where people can go? And as well as with the mental health aspect, sticking to it again, just for education purposes only. And also, we are making sure that we're not messing with the age range, which is insert in 172, which is on page 2, line 17 after 411. And we're also striking, adding language relating to the matter that if a student makes an outcry related to domestic violence, sexual assault, or mental health, the instructor shall refer the student to a licensed instructor. Chairwoman Thompson and members, thank you for your time. I will close unless there are any questions. Reserve the right to close.
Chairman King.
So I noticed that this is for grade 12.
Yes, sir.
What was the thought process? Do you know? You know, Representative, why they chose grade 12 instead of 11? Or
I chose grade 12 because students are getting ready to go to college. We know that dating violence is something that I wouldn't say increasing. We're now more understanding of it. And my thought process behind it was, before our students are going to college and they're becoming adults, getting them prepared to understand the different areas of where the law is. So then that way they understand what are their rights as a firearm owner, understanding where to go if they need help with sexual assault, domestic violence, if they're a witness to it, if they feel they have any mental health issues. That way it kind of teaches them, well, you're becoming a responsible adult. Here you can go, and these are the places, and these are the resources.
Thank you.
Yes, sir.
Any further questions? Thank you. We reserve your right to close. Andrew Brown, Michael Belsick, Lisa Ross. Do we have enough? Nicole Golden. Nicole Golden. Lisa Ross, we show you as representing Lock Arms for Life and yourself, and you are for the bill. Is that correct?
That's correct,
You
yes.
may proceed.
All right, thank you very much. Let me kind of turn this way.
You have 3 minutes.
I've got information that I'm actually handing out to you guys. So yes, Lisa Ross, I'm a board member of Safe Kids Austin, which is part of Dell Children's Hospital. I'm also the founder of Lock Arms for Life. How I became founder of Lock Arms for Life is I lost my 23-year-old son to a gun tragedy. He was a college student, and a firearm was sitting on a coffee table. A friend handed it to him one night at a party. He didn't know it was fully loaded. He had to put it towards him, discharged, and he killed him. So what I do now is I do a lot of education. I educate young adults about making sure firearms are stored safely. I definitely support this bill 100%. I think it really provides an opportunity to teach young Texans about gun safety, safe practices, and other valuable lessons that they need to learn. And you'll see in my flyer right there that we have a program that's called Get Active for Firearm Safety. It's what we do right now. We have done many educations. In fact, I'm just going to tell you a real quick story about one of the education programs that we did do. So my organization in 2019, we were selected it was really part of Dell Children's Hospital, and it was called the Eastern Association for Surgery Trauma. It was a national conference that was held here in Austin, Texas. And they were doing education on distracted driving, control the bleed, and one of the other ones is that they wanted somebody to come in and talk to the students about gun safety. It was an elective course, like your bill says, and of the elective bill on it, of the course, there was like 450 students that actually signed up to take the course at the time. And we educated all of those 400. What we did is we went ahead and we did a presentation to all of the students. We told my personal story that was involved in there. Then we talked about suicide prevention. And then I brought in a police officer because I'm an alumni of the Citizens Police Academy course. And myself with the PALS officer, we kind of tag teamed basically on our talking points. And he talked about 2 safe practices with firearms and what they could learn on that side of it, while I went ahead and talked about some of the statistics, again, shared my personal story, and we kind of tied it all together. And we gave away T-shirts. We had the kids sign a pledge of responsibility at the end. We gave them pins that looked just like these if they signed the pledge. Then at the end of that, too, we had them come up and we do some role playing. And the kids got to actually, if they walked into a room, what did it look like if they walked into a room and a firearm was sitting on a coffee table? What would they do and how would they respond to it? And so they got to do do that. If they did and they participated and raised their hand,
We
we
want
gave
to
a
thank you
T-shirt.
for your testimony. We show you a further bill. Members, are there any questions? Yes, sir. Chairman Capri-Leone.
Thank you. A quick question. What is it, if it's an elective, I probably should know this, but what does it take out? In other words, this is instead of what class that a student?
On this day, this particular day, it was called Injury Prevention Day, and so it was really geared around injury prevention. And so there were breakout sessions that each of the kids could sign up for as an elective.
Okay.
And so then they came into the room and they participated in each one of the segments. Like I said, Stop the Bleed was one of them, gun safety was another one. So it was kind of like that. They did a breakout session.
Okay, so this would be like another option that.
Correct. So we did it all around it. Like I said, one day, injury prevention came in, did the training. And it was 9th through 12th grade. So it was every one of the grades actually had an opportunity to sign up and participate in the program.
Okay, I got it. All right, thank you.
Sure.
Any further questions? Nicole Golden, we show that you are representing Texas Gun Sense and yourself, and you are neutral on the bill.
We support the bill. I'm sorry that change maybe didn't get through.
Just one moment.
Yeah.
Are you for the bill or neutral? Okay, then would you give us permission to change your position from neutral to for?
100%, yes, thank you.
Thank you. You may proceed. You have 3 minutes.
Thank you so much, Chair Thompson, Vice Chair Hull, and committee members. Thanks for allowing us to provide input on our support of HB 2090. Similar to what others have said, we just want to provide some input through the lens of violence prevention and gun safety. We're very grateful that the representative authored this bill and that it emphasizes community safety and violence prevention and encourages youth to identify warning signs, and really, I think in many ways just empowers them to be advocates in their communities. And we know that that's more important than ever. Because we know that according to the CDC, firearms are now the leading cause of death for American children ages 0 to 19 and have been the leading cause of death for Black children for years. And just breaking down the numbers a little bit more of the 4,163 gun deaths in Texas that the CDC reported in 2020, that included 485 were children and teens between the ages of 0 and 19. So we know that suicide accounts for many of those. The Texas Suicide Prevention Collaborative reported that 2020 was the first year that more than 50% of suicides by youth were completed by firearm. And so I'm just giving this all to you to let you know why we think that this is of huge value. And we would just love if there was any opportunity to ensure that the curriculum includes steps to secure firearms safely to prevent these kinds of preventable tragedies. And I just want to flag too that Texas's Keep 'Em Safe Texas campaign is run by DPS and is an excellent resource in that regard. And so are others like Lock Arms for Life. And we're just happy to be a resource as this curriculum is put together, and we hope that this legislation is successful. We want to see youth be empowered to be advocates for violence prevention in their communities. Thank you.
Members, are there questions? Thank you. And Andrew Brown, we show that you are representing the Public Safety Policy Foundation, and you're for the bill.
Yes, sir. Texas Public Policy Foundation.
I apologize. Texas Public Policy Foundation, and you are for the bill.
Yes, ma'am.
You have 3 minutes.
Good evening, Chair Thompson and members of the committee. My name is Andrew Brown. I serve as Associate Vice President for Policy at the Texas Public Policy Foundation, testifying in support of House Bill 2090. I want to thank Representative Manuel for bringing this bill and for dialoguing with us on what his goals and what he's trying to accomplish, which we are 100% in support of. I grew up in an ag family, and from an early day, firearms were part of life on my grandparents' Angus cattle and tobacco farm in Oldham County, where I spent summers and just about every holiday during my childhood. And when me and my cousins were growing up, before we were ever allowed to touch a firearm, our fathers and our papa gave us an informal course. And that course dealt with proper care, handling, as well as, and most importantly, safety. And to this day, there's one thing that was said in that course that rings in my head every time I go to handle my own firearms. And I remember my father looking me dead in the eye. I was probably 8 or 10 years old. And he says, "This is a tool, son. If you do not respect this tool will kill you or it will kill someone else. And not a day goes by when I get my firearm out of its locked safe in my closet to take it to the range or whatever, that I don't think about that first. And that's an opportunity that I feel lucky to have had. And it's an opportunity that I know many of my peers growing up and many students today do not have. And education around firearm safety, I believe, is one of the most important things that we can do to address not only gun violence in this country, but accidental deaths and injuries resulting from firearms. The more you know about the gun, the more you respect the gun, the better able you are to approach it safely and with the respect that it deserves. So we think providing students with this opportunity to elect this class as part of their school, and even the inclusion of the handgun course that's already in code that is offered to Texans is a great addition to this bill, and we are proud to support it. Thank you.
Members, are there any questions? Thank you very much.
Thank you.
Thank you. Molly Vallis. Molly, we show that you're representing the Texas Council on Family Violence, and you are for the bill.
Yes, that's correct, and I'm sorry, I've got a soft voice. I'm gonna bring it in so y'all can hear me. Thank you, Chair Thompson. Thank you, Vice Chair Hull. Both of you have been champions for survivors for many years. We believe this bill will continue that. I know many of you representatives every day think about survivors and their families and how we can make a safer state. I'm proud to be the Director of Public Policy at the Texas Council on Family Violence. Certainly, we help to think through public policy solutions, but we also have a team dedicated to prevention efforts in our state, because we all dream of a state where no violence ever happened for anyone. We're extremely excited to see House Bill 2090 from Representative Manuel, because we believe it's a strong step towards the prevention we know can create a safer Texas. I know each of you have heard about the school shootings in our state, the shootings at Sutherland Springs, Uvalde, and I know each of you think about solutions that might help. That I feel confident of. What I can tell you is that underneath 70% of mass violence in our state is dating or domestic violence. And so this bill, which would put an elective optional course for 12th graders to take, would help make the connection that we know every bit of research has told us is true, that if we can help people understand what is a healthy relationship coupled with how do we safely use a handgun in the manner the gentleman just offered, that we can work together to create a safer state. I believe that the solution will be many factors, but that this is one. So we're really excited to kind of raise that forward. And I heard a great question you asked earlier, Chair Capriglione, about why 12th grade. And I want to say one of the things we know is that about half of all violence occurs on school grounds. And that right as you go to college is an important time when you're seeking your independence to have this kind of education and to pair it around firearm safety. So I really appreciated that question. I would say, especially because of the rates of violence we also see in community colleges and in college, this is an important time. We're happy to serve as a resource on it and just hope y'all vote this favorably out, and happy to answer questions too.
Members, are there questions? Thank you very much.
Thank you.
Michael Belsick had signed up to represent himself, and he was against the bill, and he did not testify. Is there anyone else here wishing to testify on, for, or against House Bill 2090? If not, the testimony on House Bill 2090 is now closed, and the chair recognizes Representative Manuel to close on his bill.
Chairwoman and members, thank you so much. Not to go too long, but I think everyone has kind of summarized why this piece of legislation is very important. Unfortunately, by the time I was 16, I had to deal with the reality of 6 out of 10 of my female friends were either raped or sexually assaulted I have a mother who was in a domestic violence situation growing up. I think that when we are teaching our young people to respect each other, to respect the tools around us, we can have a safer Texas. We can allow people to be personally responsible. And I think having multiple groups come together saying that this is something that can help all Texans, I think it's wonderful. And I appreciate so much your consideration and your time. And I close, Chairwoman. Thank you.
Members, are there any questions of Representative Manuel? Thank you very much. Members, the chair moves to withdraw the substitute and leave House Bill 2090 pending. Are there any objections? The chair hears none. The substitute is withdrawn, and the bill will be left pending. The chair now lays out House Bill 3255 and recognizes author Representative Manuel to explain the bill.
Chairwoman, members, thank you again for the opportunity to present this bill. HB 3255 seeks to amend the Education Code to require the principal, the assistant principal, school marshal, the school district peace officer, school resource officer, and school security personnel employed by or assigned to a school district to undergo the FEMA National Incident Management System and Incident Command Systems training. Currently, the first responder agencies that partner with schools use the incident command during a crisis. NIMS is essentially the guide for all levels of government, non-governmental organizations, and the private sector to work together to prevent, protect against, mitigate, respond to, and recover from incidents. The incident command system determines the role of everyone responding to a crisis and defines a shared vocabulary and shared expectations of behavior. It aids in learning to understand and speak a common language during a crisis. This is imperative to a successful outcome during an emergency. HB 3255 works to mitigate risks while dramatically increasing preparedness in the event of a critical incident. Each course is free and is available online at the FEMA website. These courses result to between 2 to 4 hours upon completion of course. The training is a comprehensive approach that can apply to emergencies of all types and sizes. HB 3255 will require the Board of Trustees to provide annual emergency response management training exercises incorporating the trainings learned. Chairwoman and members, if you have any other questions, if not, I will reserve the right to close.
Members, are there any questions? Jeffrey Yarbrough. Chief Yarbrough, we show you as representing yourself, and you are for the bill.
Yes, that's correct.
Okay, you may proceed. You have 3 minutes.
Madam Chair, Madam Vice Chair, distinguished members of the committee, thank you for this opportunity, and I thank Representative Manuel for bringing this important bill, this proposal to the committee and the legislation. We all have heard the saying, the more things change, the more things stay the same. Well, I say no, they don't, no, they can't. Because there was a time when we lived in a different time, we lived in a different place. There was a time when you can leave the doors and the windows open in your school so that the fresh air can come in and nobody thought anything about it. But now those days are gone and I miss them. But I will say that there was also a time when the only drills that we had in schools were the fire drills or the duck and cover drills. But now we're asking our school administrators to be more prepared for a variety of situations and issues that can take place in a school that range from natural disaster to human-caused events. In this training, when it comes to the incident command and national incident management training, is another component that helps us to make sure that our schools are prepared to respond effectively and efficiently to make sure that they're taking care of our students in the event of a crisis, so before first responders arrive. There are situations like, say, for example, when it comes to fire drills or it comes to shelter-in-place drills. I was the former chief of police of Bastrop ISD, started that department, also started Round Rock ISD Police Department, and we required our administrators and our law enforcement officers to be trained in the incident management and also the incident command systems. The reason being is when you have critical incidents that occur, sometimes, like for example, perfect example, a year ago, when we had the tornado that came through Round Rock, the first responders and the emergency communications experts, their resources were extremely taxed to the point to where they were providing services to many cities that did not have the resources, and it was expanded the entire county. Fortunately, some schools let out early, Round Rock didn't. Thankfully, the storm did not hit at the same time when students were leaving, but what we did was we made sure, and at the time I was the chief there, we made sure that the staff were prepared and we were able to implement incident command so that in the event of a critical incident, we were able to respond effectively, efficiently, and join in with the partnership of our law enforcement partners and our first responders in the area. Our administrators were trained to have what we call unified command in the event of a critical incident. They could join together with other resources, but they can also transfer that command. So you're not learning on the job, and you're building confidence through competence.
Thank you, Chief Yarborough. Members, are there any questions? Thank you very much.
Thank you.
Is there anyone else here wishing to testify on, for, or against House Bill 3255? If not, the testimony on House Bill 3255 is now closed, and the chair recognizes Representative Emanuel to close on his bill.
Thank you, Chairwoman, and members of the committee again. I cannot say that any more eloquently than he did, and I have been learning from him. But I think the essence is we all want to make sure that we're protecting our communities, our children, and our family. And I think this bill has a very good, opportunity of doing that. And I thank you all for your time. If there are any questions, and I look forward to working with anyone on this and doing what we can to help. Thank you so much, and I close.
Members, are there any questions? Thank you. Members, the chair moves to leave House Bill 3255 pending. Are there any objections? The chair hears none. The bill would be left pending. The chair now lays out House Bill 1972 and recognizes its author, Representative Campos, to explain the bill.
Good afternoon, Chairwoman Thompson and Vice Chair Hull and members. Hope you all are doing great this evening. Thank you for the opportunity to lay out House Bill 1972 regarding children placed by DFPS and residential treatment centers. House Bill 1972 is based on statute recommendations in the 2022 Children's Commission report to the Texas legislature. In effect, this bill seeks proactive monitoring of a child's placement in a residential treatment with the goal of expediting the children's return to a strong family setting. Residential treatment centers provide therapeutic residential care for minors and address mental illness, substance abuse, or behavioral health problems. These children will live in a RTC for a short period of time as they work to meet their treatment goals. Typically, other outpatient services did not provide the necessary help for these children, and they were unable to be supported at home or in a community due to mental health needs. The RTCs are very important for children who require intensive mental treatments. The problem is that children are often left for too long in these facilities, creating long-term problems for children, like being unable to find a permanent home. A quick return to a family environment is also recommended due to concerns of abuse in RTC settings. While only 5% of foster children are placed in RTCs, more than 1/3 of reported abuse and exploitation happens in these settings. House Bill 1972 provides court oversight requiring a judge to proactively monitor the child's progress in their RTC placement so that they can return quickly and successfully to a family setting. After 60 days of placement in an RTC, a judge will review the child's well-being and confirm the RTC meets the child's needs and goals. This bill will also provide a statute definition for residential treatment center in Section 263 of the Texas Family Code so that everyone involved in CPS cases are using common terminology. I'm open for questions and respectfully reserve the right to close.
Members, are there any questions? Thank you. Kate Murphy, Jaime Bernstein, Rob Hoffman. Jamie. Kate Murphy, we show you as representing Texans Care for Children, and you are for the bill.
Yes, ma'am.
You have 3 minutes.
Yes, thank you. I'm Kate Murphy. I'm the Director of Child Protection Policy for Texans Care for Children. We support HB 1972. Every child deserves to grow up in a loving family. Right now in Texas, we have about 1,200 children who are in residential treatment centers. And unfortunately, right now, this is a place where kids tend to languish. And as you heard from Rep. Campos, they experience worse outcomes. They're more likely to age out of care. They are less likely to find a permanent home. They're less likely to graduate high school. So we really want to do a better job of wrapping around these kids who have higher needs, who have complex mental health needs, who are in residential treatment centers, and make sure that we're doing extra work and taking extra care to make sure that they're okay, that they're safe, given the higher risk of abuse that she also highlighted. The goal with this bill, and I really want to emphasize this, is not to add a lot of new work to what caseworkers are already doing. It is to make sure that that work is known and made available in court hearings where we're already talking about a child who may be placed in a residential treatment center. So you'll see going through the bill that there's language in there with new findings for court hearings, and this is really, really focused on making sure that we're just presenting information that DFPS should already have and is already collecting to the court so they can make informed decisions and have really intentional conversations around how to protect the most vulnerable kids on their dockets and the kids that we should be using extra care for. So that's
Members, are there any
happy to
questions?
answer questions, yeah.
Thank you. Okay, Jamie Bernstein.
Hello, thank you, Chair Thompson and committee members. My name is Jamie Bernstein. I'm the Executive Director of the Supreme Court of Texas Children's Commission, and I'm here as a resource on House Bill 1972. For those of you who aren't familiar, the Children's Commission administers a federal court improvement program grant, and our mission is to strengthen the courts and thereby improve safety, permanency, and well-being outcomes for children. During the 87th legislative session, Senate Bill 1575 added requirements related to the Qualified Residential Treatment Program, or QRTP, court review. It also charged the Children's Commission to create a work group to consider the appropriate use of and transition into and out of residential treatment center, or RTC, placements, including, I'll say in relevant part, statutorily required judicial review of RTC placements, the fiscal implications of additional judicial review for RTC placements, and proposed statutory changes regarding these appropriate judicial findings. The proposed changes in House Bill 1972 reflect the recommendations made by the work group, so I want to share just a little bit about the process that we had to develop these recommendations. The Senate Bill 1575 work group was chaired by Judge Rob Hoffman, who's here with us today to serve as a resource as well. The work group included subject matter experts from all around the state that represented DFPS, the Texas Juvenile Justice Department, HHSC, single source continuum contractors, and service providers, as well as judges, attorneys, and advocates. There were two subgroups. The legal subgroup developed the recommendations before you today related to the court review of RTC placements. That group had a similar composition to the Senate Bill 1575 work group, but also included the Ombudsman's office, which we thought was an important perspective. We also consulted individuals with lived experience throughout the process, which spanned from September 2021 to July of 2022. And I want to state very clearly that our approach through this legal work group was to leverage existing court hearings,
court requirements and documents that are already available to the court so that courts can be informed about whether the RTC is the right fit for the right child for the right amount of time. I defer to Judge Hoffman to explain the recommended changes, but I'm also available for questions.
And you're testifying neutral on the bill?
That's correct. Thank you.
Okay. Judge Rob Hoffman, you're representing the Texas Children's Commission, and you are neutral on the bill.
Yes, ma'am.
You may proceed.
All right, thank you. Good afternoon, Madam Chair, members of the committee. My name is Rob Hoffman. I'm the District Judge of the 452nd Judicial District Court of Texas, and also the Senior Jurist in Residence for the Texas Children's Commission. I have the pleasure of serving currently as the Treasurer for the Board of Directors of the National Council of Juvenile and Family Court Judges. And as Jamie testified earlier, I was the chair of this SB 1575 work group from last session. The recommendations of this bill are recommendations directly related to the work group. The issues presented in the bill, as already has been testified to, simply set parameters for enhanced court review of children who are placed in residential treatment centers, and also a subset of those centers called qualified residential treatment programs. It instructs judges on what determinations they make about these placements in RTCs, and also what information that they have that they base those recommendations upon. The recommendations enjoy a very broad consensus from the folks that Jamie mentioned were present in the work group, and they also provide great judicial oversight so we can improve the safety, permanency, and well-being of children in foster care, and also provide accountability and transparency of the agency. Several current courts across the state of Texas already review RTC placements more strictly, and some even have additional hearings upon which they base that information and make those findings. They report anecdotally to us that those hearings are very important in determining the best interests of children, especially those children who we hope do not languish in residential treatment centers. As has already been testified to, the good news is that this bill does not require additional documentation or reports to be provided to courts by the agency. It's simply using the reports and information that the agency and other folks already have. Additionally, it does not require additional hearings to be held by courts, creating additional costs for the agency. Some courts already have additional hearings and currently have the authority to do that. That authority is not addressed at all in this bill. Simply, these recommendations simplify and put parameters around the process for courts to have greater accountability, leverage existing documentation, and use existing hearings to keep a closer eye on these children placed in these very restrictive placements and make sure that they do not languish there. So, Madam Chair, thank you.
Members, any questions? Okay, thank you. Is there anyone else here wishing to testify on, for, or against House Bill 1972? If not, testimony is now, testimony on House Bill 1972 is now closed, and the chair recognizes Representative Campos to close on her bill.
Again, thank you, members. And just to confirm that this bill seeks to make sure that children, get back to a good family environment sooner than later, that they get the help that they need. And I think all of us are trying to do the same thing for all of our Texas children, and that's just to make sure they get the help they need and that we get them, in a good environment, and just do the best that we can, because they are our future, so we need to work hard to keep them safe. Thank you, and I close.
Members, do you have any questions? Representative Campos? Thank you.
Thank you.
Members, the chair moves to leave House Bill 1972 pending. Are there any objections? Chair hears none. The bill will be left pending. The chair lays out House Bill 2111 and recognizes its author, Representative Allison, to explain the bill.
Thank you. Thank you for the opportunity to lay out House Bill 2111. In the aftermath of some of the school shootings, and particularly Uvalde, there's been interest in engaging people with greater experience and background in law enforcement, and particularly at the federal level, to assist in overall school safety and security on a district and statewide level. including at local school districts, and also the governor has engaged such a person to head up safety and assigned him to TEA. The problem that's been developed is some of these people, although well-qualified, highly trained, and highly experienced, are not authorized under the education code currently to carry a firearm. So House Bill 2111 attempts to address that, and in the interest of time and get people here with better expertise and knowledge about the situation than me, we have witnesses that are intimately involved with the situation and the need for the address that House Bill 2111 attempts to accomplish. So I will defer to them to provide the additional testimony and answer any questions.
Members, any questions for Representative Allison? The chair calls up Michael Belsick, Wesley Verdell, and John Scott. Are you John Scott?
I am, ma'am, John Scott.
And we show you representing the Texas Education Agency, and you are neutral on the bill. Is that correct?
I am, yes, ma'am.
Perfect. You proceed.
Yes, ma'am. My name is John Scott. I am the Chief of School Safety and Security at TEA, and I'm here as a resource witness, happy to answer any questions that y'all might have.
Mr. Scott, if you could maybe give some of your background experience and why you're in the position that you are today.
Yes, sir. Regarding this bill, I have extensive training in weapons handling, firearms. Most of the people, all of the people that are here, the former federal agents, you know, they were all authorized to carry weapons while on duty on campuses. They still have that skill set. They still have those that knowledge, and it would be beneficial, you know, a force multiplier to allow them to carry the weapons in their current capacity. Many of those folks are being sought after and hired by school districts as the director of security or other titles, but to help organize the security.
In fact, you've been engaged by the governor and assigned to TEA to direct it on a statewide basis. Is that correct?
Yes, sir. That's correct.
And what is your background in federal qualification, federal background experience, particularly in firearms and training?
Yes, sir. I spent almost 23 years as a Secret Service agent, United States Secret Service agent. So I'm intimately familiar with protection, weapons handling, and weapons employment.
But as it currently stands, you're not able to carry a firearm on a school within Texas, are you?
That is true, yes, sir, I'm not.
And that's what House Bill 2111 attempts to address.
Yes, sir.
Okay, thank you very much.
Yes, sir.
Members, any other questions? Thank you.
Thank you.
Chair calls up Paul Duran. Show Paul Duran, Northeast ISD, and for the bill?
That's correct.
Thank you.
Good afternoon. Thank you for the opportunity to speak with you today. Again, my name is Paul Duran. I'm representing the Northeast Independent School District in San Antonio in support of House Bill 2111. I'm currently the Senior Director of Safety and Security for Northeast ISD, having recently retired from the U.S. Secret Service after about a 30-year career in a variety of assignments, which included assignments to the Presidential Protected Division and the Counter-Assault Team. My experience with the Secret Service has given me firsthand knowledge of the need and importance for security planning, emergency operations, threat assessments, and really looking at the prevention of targeted violence as related to, providing for safe and secure environments for national leaders. And in that spirit, I felt that these types of skills are aligned specifically with the mission of keeping our schools safe from a diversity of threats. School safety and security, much like presidential protection, involves a system of interrelated elements that need to work together. And many of my responsibilities right now as the Safety and Security Director for Northeast ISD, involved or require coordinating a variety of stakeholders in order to provide the safest environment for our students, staff, and facilities. The Federal Law Enforcement Officer Safety Act grants me, as a qualified retired federal agent, the authority to carry a concealed weapon in any jurisdiction within the United States. However, does not supersede certain state laws that prohibit or restrict possession of a firearm in certain local or state government properties and private properties, such as school safety zones and such. So my past training with the Federal Law Enforcement Training Center, with the Secret Service Special Agent Training Academy, and nearly 30 years of in-service training, more than qualify for the TCOL credit for training, but does not provide for specific Texas Penal Code credit in order for me to receive peace officer status in Texas. However, my position and responsibilities in safety and security for the district are not of a law enforcement nature. House Bill 2111 would essentially allow myself or other qualified retired federal agents to carry a firearm while on duty and in their official capacity as a district's security personnel representative. And of course, in a crisis situation, would then have the ability to intervene if necessary in order to protect life. I spend approximately 50% of my time in any given week on campuses in our district, supporting safe and supportive school program teams, conducting safety audits, and just doing continuously evaluations of our facilities for vulnerabilities. And I would just hate to have the skill and ability, but not the tools to be able to immediately provide some sort of immediate response to a life-threatening situation or an active shooter incident that I was present at. House Bill 2111 could act as a force multiplier to school resource officers and first responders to enhance school safety. As part of our district's emergency operations plans, carrying my weapon would also support prolonged incidents and safety at reunification sites or other emergency operations. So I thank you for your time and consideration, and I'd be happy to take any questions if you have any.
Members, any questions? Representative Allison? Oh, no, okay. Okay, thank you.
Thank you.
Sean Micah? Micah?
Very good. You pronounced that perfectly.
Thank you. Show you with Northeast ISD for the bill?
Yes, ma'am.
Thank you.
Yeah. Thank you, Madam Vice Chair, and thank to the committee for still being here this late and listening. I appreciate it. I am Sean Micah. I am the superintendent currently of the Northeast Independent School District in San Antonio, and I'm here in support of House Bill 2111. In 2019, I had the good fortune to become a superintendent in the state of Texas in San Antonio. And nothing prepared me to take on the weight of the safety of over 64,000 kids and 8,500 employees at that moment. Nothing prepares you for that moment. When the tragedy in Uvalde happened, I was really left with, what next? I'm blessed that we have an NEPD police force right now in our district, but that's all about response. What I was really looking for is how to be proactive. So I had the good fortune, my board approved the Senior Director of Security and Safety, which he just shared his testimony, Mr. Paul Duran. But I had the good fortune to hire him as a former Secret Service agent to come in. And so as I sat with Paul and we discussed his role in safety for the school district, I can tell you I was very shocked when I learned that he could not carry his weapon. Even though he had over almost 30 years of training in it. And so while Paul's real job each and every day is just as he described, which is really about a proactive approach, House Bill 2111 gives us yet another tool and some flexibility in the school district in response to any sort of potential threat or life emergency. So again, while Paul's sole job really is about proactive pieces, as we discussed the other day in preparing to come here this evening, Paul simply, if there was ever a crisis in one of our schools, he does not want to be a bystander, he wants to be involved. House Bill 2111 would allow him to do that. Thank you so much, and I'm available for any questions you may have.
Members, any questions? Thank you.
Thank you.
Michael Belsick, show him for the bill, but he did not testify, and Wesley Verdell, also for the bill, but not testifying. Is there anyone else here wishing to testify on, for, or against House Bill 2111? If not, testimony on House Bill 2111 is now closed, and the chair recognizes Representative Allison to close on his bill.
Thank you. I'll be brief. I think the testimony from the three outstanding witnesses show the need to fill this gap, I think an inadvertent gap in our current education code. We're devoted so much to school safety and devoted so much to making sure that we have people that are properly qualified, have background training and expertise to handle the responsibilities. I think these witnesses show the importance of that and why we need something like House Bill 2111. So with that, I respectfully ask for favorable action on this bill, and with that, I'll close.
Members, do you have any questions for Representative Allison? Thank you, Representative Allison. Members, the chair moves to leave House Bill 2111 pending. Are there any objections? Chair hears none. The bill will be left pending. The chair lays out House Bill 4091 and recognizes its author, Representative Ann Johnson, to explain the bill.
Thank you, Chairwoman. Members of the committee, I am grateful for a chance to bring you House Bill 4091. Everybody has heard about kids in CWOP, kids that are in CPS but don't have proper placement. We recognize that there are kids that are in acute crisis, and there are kids that are often in foster care, but many of those kids that are dropping into CWOP are somewhere between and need some assistance with subacute care. We are very fortunate to have UT Health and some of the programs that they are doing in Houston, with a setup with DFPS, the Department of Family and Protective Services, to try to provide that subacute treatment, which would be inpatient treatment of around 60 days for some of these kids in transition.
We're going to lay out your committee.
And I have a committee substitute.
Representative Dutton offers up a committee substitute. The chair lays out the committee substitute and recognizes Representative Johnson to explain the substitute.
Thank you. And the committee substitute is technically in Ledge Council version, but the substance is the same. And this bill would actually provide the statutory authority to ensure that we have the ability to create the subacute care that can potentially be provided for UT Health for DFPS and would serve a great need in a great population. We do have a number of witnesses to testify on support of this bill, and I would be happy to answer any questions and also reserve the right to close.
Members, any questions? Representative Johnson? Thank you.
Thank you.
The chair calls up Steve Glazer. Did I get your last name right?
Yes, Glazer.
And we show you with UT Health Houston, and you are neutral on the bill.
Correct.
Thank you.
Thank you, Vice Chair Hall and committee members. My name is Steve Glazer, and I'm the Vice President of Business Development and Government Relations for UT Health Houston Behavioral Sciences Center, and previously the Chief Operating Officer of UT Health Harris County Psychiatric Center for the past 9 years. Today, I'd like to speak to you about HB 4091 and its impact on mental health of troubled youth and conservatorship with DFPS. For the past 7 months, UT Health Houston has been working with DFPS to create a treatment program designed specifically to meet the clinical needs of those children in DFPS custody who may have continued need for hospital-based care beyond the acute care phase and are still too unstable to be successfully transitioned into residential treatment or back into foster care. This new program, which we have named Successful Transitions for Adolescents Recovery Trajectories, or START, is a pilot program designed to provide extended stabilizing mental health treatment in a therapeutic hospital-based environment for children and youth who would benefit from additional therapy and treatment in a longer-term hospital stay. The goal of the program is to ensure that some of our most troubled youth develop skills needed to successfully integrate in their new environment and to prevent repeated foster placement attempts or children without placement. Most acute care psychiatric hospital stays for children or youth typically last about 6 to 8 days, but for many, this is just not enough time for them to be sufficiently treated to the point where they can be successful in residential treatment or returning to foster care. START is designed to provide individualized and intensive therapy to address long-term issues like trauma, depression, anxiety, substance abuse, and behavioral concerns. START provides a critically needed level of care where patients will stay around 30 to 60 days. The pilot program is modeled after and contains many of the elements of UT Houston's successful subacute treatment program for adults. This program has shown significantly improved outcomes for its participants and has been published in multiple peer-reviewed academic journals. Chair Thompson just returned. I know you're very familiar with that program as you instituted the budget writer that instituted and funded it back in 2013. We're now about to expand this successful adult program at the Dunn Behavioral Sciences Center, and we're hopeful that our parallel program for youth in foster care will show the same successful results. Since this new program envisions longer-term hospital-based treatment, the admission criteria is appropriately broader than you would see for an acute care program. The existing statute gives DFPS the authority to admit children in their custody who meet typical acute care criteria. The amendment in HB 4091 narrowly expands that clinical admission criteria to ensure that children who need this type of program will not be left out. Changes in foster care children in foster care frequently face significantly more behavioral health challenges than most other children, often because the trauma or abuse that they have experienced. This program is designed specifically to allow those children who need more time and more treatment to get that level of care that they need. This bill will help us to ensure that any child in Texas who needs this intensive and innovative treatment will be able to get access to that treatment in a timely manner. It's also worth noting that funding for the START program for FY 24-25 is currently included in DFPS bill pattern in both HB1 and SB1. This time I'd be happy to answer any questions.
Members, are there any questions? Thank you so much for your valuable testimony.
Thank you.
Thank you. Is there anyone else here wishing to testify on, for, or against House Bill 4091? If not, the testimony on House Bill 4091 is now closed, and the chair recognizes Representative Johnson to close on her bill.
Thank you. Appreciate your support of this bill, and I close.
Any questions, members? Representative Johnson. Members, House Bill 4091 moves, the chair moves to withdraw the substitute and to leave House Bill 4091 pending. Are there any objections? The chair hears none. The substitute will be withdrawn and the bill will be left pending. The chair now lays out House Bill 2919 and recognizes Representative Johnson to explain the bill. Representative Johnson, let me let Chair Dutton lay out your substitute and you may proceed.
Thank you, Chairwoman Thompson. Members, this bill came up because when I was Chief Human Trafficking Prosecutor and handling cases where 17-year-olds were charged with prostitution. Many times they were locked in custody, but we believe they were probably victims or compelled into prostitution as the statute protects under the age of 18. So you have this population of 17-year-old kids that are often locked in the adult system facing adult conviction, and they are given an attorney. That attorney, and the responsibility is for us to argue on behalf of what that individual wants. The challenge for prosecuting this 17-year-old population in the adult system is that if they don't have a parent or somebody else there to say, wait a minute, is this in your best interest? Is this in your best interest to take a conviction for prostitution, a crime of moral turpitude? Or is this in your best interest to plead guilty to theft? And in a couple of scenarios where I had a question of whether or not there was a conflict of interest between the defense attorney representing what that 17-year-old was saying what they wanted versus what may have been better for that individual, I would ask the court, hey, help us intervene here and appoint a guardian ad litem. Somebody that can step in and say, nope, we need to get you to a shelter, we need to get you away from this situation, and try to articulate another means. And the judges would always say, Ann, great idea, but I have no legal ability to do it. And so that's what this bill would do, is add an opportunity where there is a conflict, where the attorney who is representing the individual cannot do both, say what the client wants and what may be in the best interest, that upon motion of the court, the prosecutor or another party or the defense attorney ask for the appointment of a guardian ad litem. There is a committee substitute, and the substitute is, the language currently says shall. I have met with the County Attorneys Association, and they have asked to make that change from shall to may, just to be clear that we're not talking about every circumstance. For me, it was rare that this came up. But when it came up, we didn't have the ability to do anything different, and this is part of the challenge with having this population in the system. This would also apply in juvenile. It does now. We do it all the time in Harris County, but it would ensure that other counties equally have the ability to have somebody step in to the role of best interest where there is a child that doesn't have somebody there doing it for them. I'm happy to answer any questions. I appreciate the opportunity to close.
Thank you. There are no witnesses, members. Is there anyone here wishing to testify on, for, or against House Bill 2919? If not, the testimony on House Bill 2919 is now closed, and the chair recognizes Representative Johnson to close on her bill.
I close.
Members, House Bill 2919, the chair is going to move to withdraw the committee the substitute and leave House Bill 2919 pending. Are there any objections? The chair hears none. The substitute is withdrawn, and the bill would be left pending. The chair now lays out its final bill, House Bill 1927, and recognize Vice Chair Hull to explain her bill.
Thank you, Madam Chair, for allowing me to lay out House Bill 1927. My layout is a little bit lengthier than normal because I've had a lot of questions, so I'm hoping to address that in my layout. Currently, an apprehension by a peace officer without warrant, often referred to as an emergency detention, allows an officer to take a person into custody if the officer has reason to believe that the person has a mental illness and is a substantial risk of serious harm to themselves or others, and there is no time to obtain a warrant. The officer then transports the person to a mental health facility and files a notification of detention with the facility. While these detentions may make sense for an adult experiencing a crisis who has all the rights of majority that adults have, these detentions are currently equally applied to children. Importantly, children do not have the rights of an adult and do not have the right of custody and care for themselves. Their parents do. An emergency detention of a child is not removing a person of their right as an adult. It is detaining a child without providing a right for the parent to take custody of their child and without even notifying them. Importantly, a parent in these circumstances has the right and duty of care and custody and has not had their rights limited by a court. House Bill 1927 ensures that parents are granted the right of care and custody of their child by requiring an officer to attempt to contact a parent and document the attempt before detaining a child. It also allows for parents to intervene and take custody of their child to seek the treatment that best meets their child's needs. If taking place at school, the attempt to notify the parent must be documented in the school record, and the school must notify the parent. Finally, House Bill 1927 requires that a peace officer taking any person into custody use age-appropriate trauma-informed practices in responding to the situation and prevents an officer from using handcuffs, electrical devices, or chemical agents on a child 10 or younger. This bill is not preventing a detention of a child. In many instances, parents may want their child transported if they believe it is an emergent situation and they have no other options. Unfortunately, we have seen many instances in which parents are well aware of their child's mental health needs and that the child is already receiving treatment from their chosen providers. Imagine knowing you have been working to help your child with therapy and medication treatment, and unbeknownst to you, they are detained at school and transported to a private facility that does not have any medical information about your child or their treatment. This can and does happen. I want to share with you this story that was shared with me from a father in North Texas. In 2017, my daughter was taken into custody at school, handcuffed, and transported from her high school to a private behavioral health facility. Later, the school counselor said that my daughter had expressed thoughts of suicide, depression, and she wanted her to get inpatient treatment. My wife and I were notified, we were informed, my wife and I were not informed that this was happening. We were not against mental health treatment. In fact, my daughter was under the care of a team of psychiatrists plus a psychologist. She had been successfully treated at a different hospital in the not too distant past. We had the opportunity to intervene and take custody. We would have taken her first to her psychiatrist with Children's Medical Center in Dallas, and then if her treatment team had found it necessary, we would have taken her to the hospital we'd used in the past, which at least was very open and transparent with us, and in which my daughter had been treated decently. Instead, she was handcuffed, taken to a place with which she was unfamiliar. My wife and I were not contacted. We assumed she'd stayed after school tutoring. When I went to pick her up at 3:30, she was not there. I asked a friend of hers who said she had not seen her all day. My wife began frantically calling all of my daughter's friends, and to no avail. Finally, at 8 p.m., I got a call on the landline that we do not normally monitor. It was from Child Protective Services asking me if I knew where our daughter was. She explained that my daughter had been taken to a facility and that I needed to go there to fill out some paperwork. We were initially relieved to know that our daughter was safe. However, this did not turn out to be the case. I went to sign papers, and at no time did they ask for my daughter's medical history or any medication she might be taking. This was dangerous. Not only did she take prescriptions for her mental health conditions, she was also on medication for diabetes. After we filled out paperwork to get our daughter released against medical advice, we were told to wait, and we were then told our daughter was being held under an order of protective custody. Only after 5 days did the facility call to get permission to give my daughter her regular medications. This means she'd been without any of her prescribed medication for 5 days. In the end, my daughter was held for 11 days. We were denied visitation, and when we did see her, it was obvious that she was not being cared for medically or otherwise. My daughter called nightly, begging to come home. She became upset and was forcibly injected with drugs. My daughter told me that they used it to discipline the kids. My daughter was drugged and, in our opinion, medically neglected without ever going to court. Conveniently, she was released before her court date. I feel that this treatment contributed to my daughter's unwillingness to get care later, and that makes sense. If help means being handcuffed and marched out of school and being taken to an abusive, chaotic institution, who would ever seek help willingly again? I believe this could have been avoided if the school or law enforcement had contacted us and given us the opportunity to take our daughter to her already established treatment team. This father stated that his daughter never recovered from this trauma and mistreatment, and afterward was reluctant to engage in any treatment. She passed away of an accidental drug overdose 2 years ago. This isn't a one-time story. KXAN did an investigation here in Austin 2 years ago that found 1,500 Austin kids were forced into facilities under emergency detentions. The story also documents another family's experience with their daughter detained in a facility without their knowledge when the family had already been working to address her mental health needs. Imagine if these children, instead of being forcibly taken by law enforcement to a strange place without a known and trusted adult, were taken by their parents to their known and established healthcare providers. Taking a child to an unknown facility in many cases may disrupt already ongoing treatment and cause a traumatic setback for the child. There is no reason that an officer, especially when a child is at school, cannot contact a parent and allow them the ability to take custody of their child to seek treatment from a provider of their choice. I've heard concerns that some parents may not be acting in the best interest of their child. First, let's not assume that parents are not the person the most concerned for the well-being of their child. For the small fraction of parents who may not be getting their child needed treatment, we already have laws to address neglectful parents. Medical neglect as grounds for intervention by CPS, and law enforcement and school personnel are all mandated reporters. Many schools already have processes in place for when a child expresses suicidal ideation, requiring parents to sign acknowledgement forms and inform the school of the child's treatment plan. They also notify parents that they will contact CPS if they believe the child's needs are not being met. There is no reason that this process or something similar couldn't be in place for any instance where there is a risk of harm to themselves or others. Again, I want to emphasize that this does not prevent detentions of a child if that is what a parent chooses. This bill simply protects a parent's right to be notified and be provided the right to intervene, as it is their right to provide for the care and custody of their child. Thank you for allowing me to lay out this bill and for allowing the sort of lengthy layout, and happy to answer any questions.
Members, are there any questions? The chair calls Lee Spiller. Lee, we show you as representing the Citizens Commission on Human Rights, and you are for the bill. Is that correct?
Yes, ma'am.
Okay, you have 3 minutes.
Thank you. I have a handout there.
We have it.
All right. No, my handout.
We have, okay.
So, Madam Vice Chair, thank you for filing this bill. We think it's good legislation. In casework, we've dealt with cases like this where patients were transported against their will to psychiatric facilities, and it is traumatizing, even to adults. I can't even imagine being a kid and going through this. Right? Taking away from your only natural support system, your parents, your own doctor, living in your home, to a chaotic facility where other people in distress are acting out, where people get restrained, where you may get drugged without consent. For several years, these were the kind of cases that we worked on. Most of them started voluntarily, but occasionally we would get a detention. Now, in fall of 2019, a 7-year-old autistic boy in San Antonio was led out of school in handcuffs by police for a mental health transport while his dad watched helplessly. All he could do was video it. I didn't see anything dangerous from that kid. What I saw was a kid being led by his arms saying, "I want to go home." A follow-up story showed that over a 2-year period, hundreds of children in the San Antonio area school districts had been detained. And that's all we know, because we also don't have a reporting system. Parents deserve the opportunity to intervene and de-escalate the situation. Okay? In O'Connor versus Donaldson, the Supreme Court said a state cannot constitutionally confine without more a dangerous individual who is capable of surviving safely in freedom by himself or with the help of willing and responsible friends or family members. That's what we're talking about. We're talking about parents being able to de-escalate, avert the immediate danger, which is really the reason why people get detained. It's immediacy, right? Danger to self and others, and there's not time to get a warrant. This lets the parent step in, calm their child, and hopefully avoid, get things talked down to where then they have the time to get them home or get them to a provider and people that they know. And we think that's really important. Otherwise, we're just, we're needlessly traumatizing children. There's also the problem of detentions for no good reason. And, Florida has been working on this issue a lot, and this past month, the Washington Post did an article, and here's some examples. This year, a 16-year-old...
Lee, we thank you for your testimony.
Thank you very much.
You do support this bill, and we
Yes, ma'am.
appreciate your support. Members, are there any questions? Mr. Spiller. Chair, Vice Chair Hull.
Do you have any information on how long the detentions are, how long they can be detained for?
Yes, ma'am. So let's do a hypothetical. You come in on a Thursday night at 8 o'clock. You're detained 48 hours, but because your detention ended on a weekend, it's tolled until 4 o'clock the next business day, right? So already you're many hours into this. Then if they decide they want to keep you, then they file an application for an order of protective custody, and you're held another 72 hours before you have the opportunity to come in front of a judge. We added it up. I think in that fictional scenario, it was like 164 hours. And during COVID, visitation became a problem. And if you look at patients' rights, they have a right to visitation, but it's subject to the rules of the facility. So literally, your kid could be held again, away from you without you even being able to visit with them. All right? That's the deal.
Any further questions, members? Thank you for always staying on the job.
Thank you.
Lee, it's always good to see you.
You too. Thanks.
Is there anyone else here wishing to testify on, for, or against House Bill 1927? If not, the testimony on House Bill 1927 is now closed, and the chair recognizes Vice Chair Hull to close on her bill.
Thank you, Madam Chair. I close.
Members, are there any questions? Members, the chair moves to leave House Bill 1927 pending. Are there any objections? The chair hears none. The bill will be left pending. Members, this concludes the committee's business for today. Are there any announcements or comments? If not, Vice Chair Hull moves that the Select Committee on Youth Health and Safety stands adjourned, subject to the call of the chair. Are there any objections? The chair hears none. The committee stands adjourned.